May I please? So today I filed an affidavit in item number 6. Record of that.
May I please, Your Lordship? Your Lordship, filed to mention for listing one IA, Your Lordship, for stay vacating, Your Lordship. It was filed in the month of January, Your Lordship, but not listed. Before, Your Lordship. High level, Your Lordship.
May I please, Your Lordship, I am seeking a permission for withdrawal of a bail application on Friday. Withdrawal application, my lord, withdrawal.
Bill,
Yes, actually, my lord, because of the new rule, one FIR, same
Oh.
FIR, yes, that is why, my lord.
okay.
Deep to your question.
I'm trying to listing, yes, ma'am.
May it pleases your lordship, in item number 1, my lord, I am making mention on behalf of M. Islam, my lord. His elder brother has expired, my lord. He is not unable to come today. Along with item 24 of supply list, my lord, may be taken up after vacation.
Item 1 and 24. Therefore, adjournment is made on behalf of Mr. M. Islam, Learned Counsel for the petitioner. On the ground that he is in bereavement. So prayer is allowed list after 2 weeks.
After being vacation. Item 24 is also attached with item 1.
1 and 20.
Lordship, therefore, listed in WPC, Lordship, a matter relating to the pharmacist culture. Published.
Supplementary item 19 for motion.
Wait for some time. 19 to 23. After some time.
Daily list item 2 for admission.
My lord, if your lordship permits me to provide one list of dates. আমার কাছ থেকে আমার লিস্ট দিতে হবে আমার পেন দাও একটা আছে সব না এই পজিশনটা দেবো আমার
The term of your board was up to 25/2022.
That was earlier board. Now the present petitioners are new elected board.
Okay.
So my lord, whatever has happened with the earlier board. That got dissolved and that was approved. Now the new board has come and in the review, they have passed an order about the earlier board. But which is affecting the new board. That is why I am before your lordship.
Yes,
No,
that is the only point.
yes. But in fact, the honorable court on the last occasion directed me to produce the record. Some papers have come, my lord, but the entire record with regard to 22, which is in issue, my lord, that has not come.
But if otherwise Mr. Rajodhi is correct,
Yes.
that the
order of review was in respect of the previous board, then this board has to continue.
There is a stay
You're
order.
there.
My lord, this is a completely, I think, not correct, my lord, submissions made. Your lordship knows the boards are elected for 5 years. They are to elect, they are to hold election yearly. That is the provision of law. 5-year term is continuing, and AGM, my lord, if they do not hold it before 39 of a particular year, then it gets dissolved. Then the re-election has to be done. And under the, my lord, supervision of an officer. That is the law. my lord. So here in this case, my lord, your lordship will kindly see, my lord, only my submissions.
But that may not operate because of the fact that in the review, they took up the matter. My lord. The registrar of cooperative societies
Yes.
took up the matter in review. So therefore, that principle may not apply.
Register of Cooperative Society said, my lord, that there are earlier, because one cannot take advantage of their own wrong. My lord, 21, the meeting was held, that is, my lord, beyond the time schedule. In appeal, my lord, they dismissed my petition, but in review, it has been held. Your lordship will kindly see this review order. First order, your lordship will kindly see.
Your
it.
lordship permits me, then let me start with the
No,
fact.
he started with wrong submission before the
No,
court.
this is.
Term of the board is
attacking
for 5
personal-
years.
Let him continue that.
Let him continue. My lord. Term of the board is for last time also. My lord, he started with 22. My lord, he started with 21. 21. My lord, the board was board's life is for 5 years. You are to hold
Trying to
AGM
impose
every year.
something on me, but personally, my lord.
My
this
lord,
is not
let him
fair.
speak. My lord.
He is a
let him-
senior
let him
person,
submit.
my lord. Let them be.
22, it cannot start. My lord, it
Let
start.
me
it starts
place
with
the
year.
facts, my lord. Then your lordship will be clarified.
Yes, yes.
Let me place
Yes.
the fact. My lord, I take your lordship to page 44 first.
Just a moment. Before this, there was a motion matter. Mr. KL has come. We'll pass orders on that motion and then take up this matter. Yes, we are calling a motion matter. You got it, That's it. That's it.
Lordship, under section 168 capital A, there is a power has been given to the council. So personally, let me come to page 2. This is extract of the minutes of the meeting. Lordship, first agenda number 4,
Just now.
extension of timely history, subsection 10, section 43 of that.
CGST Act. Please make a look. Am I looking for this one? Yes.
So the power has been given to the council. Council in its meeting,
Page 2 where?
on 14th meeting, took this regulation.
Which paragraph?
Lordship, page 2.
Page
There
2
is a
I'm there.
discussion, Lordship. With regard to the entire, Lordship, there was a objection from some other states also.
And in paragraph 3, representation have been received from some tax administrators to further extend the time under section 73 CGST Act for financial year 17-18, 18-19, 19-20 to 31-12-2024, or to extend the timeline under section 73 to those under section 74 of the CGST Act. It has been represented that the difficulties were faced by the government department during COVID period due to reduced staff with strict timings and exemption to certain categories of employees from attending office during COVID period. This led to delay in process of scrutiny and audit, which could be started properly only after COVID restrictions were uplifted. It has been also been represented that though the time period for issuance of so cause notice and demand notice order for financial year 17-18 has been extended by notification number 13/22, central government dated 5/7/22, based on recommendation of the council made in 47th meeting. However, same is not sufficient considering the delay in scrutiny and an audit process due to COVID. Then paragraph 4.1. The issue was deliberated by the law commission in its meeting, law committee in its meeting held on 8/2/2023. The law committee took view that it may not be desirable to extend the timeline in such manner so that it may lead to bunching of last date of issuance of SCN order under section 73 or 74 for a number of financial years. Accordingly, LC did not agree with the proposal to extend time under section 7310 of CGST Act to timelines under section 74 CGST Act for any financial year. Further, LC did not agree with the proposal to extend the time for financial year 17-18, 18-19, and 19-20 to 31/12/2024. However, LC felt that considering the delay in scrutiny, audit and assessment process for the year 17-18, 18-19, 19-20 due to restrictions and difficulties faced in COVID-19 period, there may be need to provide some additional time under section 7310 CGST Act for the said financial year in such a manner so that there is no bunching of last date for issuance of SCN order under section 73 for those financial year as well as subsequent financial years. 4.2. LC accordingly recommended that a timeline under section 7310 of CGST Act for financial year 17-18, 18-19, 19-20 may be extended as below by issuance of notification under section 168 capital A of CGST. Then notice were recommended for 17-18 up to December 31st, 23. Then for financial year 18-19, December 23 to 31st March 24. Then 19-20 from 31st March 24 to 30th June 2024. A draft notification under section 168 CGST as per the above recommendation of the law committee is placed as an XRA. In view of the above, the agenda along with the draft notification is placed before the CGST council for deliberation approval. And accordingly, it was approved. Let's see, page 4 is the draft notification. Then page 5. Where is that gazette notification?
Gazette notification, Lordship, they have annexed with their writ petition, Lords.
Which page?
Page 44, Lordship.
But then, Mr. Kyal,
Lordship.
in view of the earlier continuous orders of the various courts, will permit you to proceed with the matter and then don't pass final orders till this matter is adjudicated.
That can be.
Let's see, further, I want to place one judgment where Supreme Court laid down the procedure, how the subordinate relationship will deal with when it is being put under challenge. So it is reported in 2024-0 Supreme SC. Naresh Chandra Agarwal versus Institute of Chartered Accountants. 2024-0 Supreme SC page 102. Page 102. Party name is Naresh Chandra Agarwal. That's a paragraph 32. Paragraph 32 laws. Yes. So from the reference to the precedent discussed above and taking on overall view of the instant matter, we proceed to distill and summarize the following legal principles that may be relevant in executing the cases where subordinate legislations are challenged on the ground of being ultra vires the parent act. A. The doctrine of ultra vires emphasizes that a rule-making body must function within the purview of rule-making authority conferred on it by the parent act, as the body making rule or regulation has no inherent of its own to make rules, but derives such power only from the statute. It must necessarily function in the purview of statute. Delegated legislation should not be traveled beyond the purview of the parent act. So here, Lord, under section 168, power has been given to the GST Council. What's the sufficiency of ground? It has been discussed in the minutes of the meeting also. Why time was extended?
No, but still you see, you are referring to paragraph 32. You
No,
see, 32A.
32A, yes, also.
But derives such a power under the statute, it must necessarily function within the purview of the statute.
Rule-making authority.
So purview of the statute, other courts have interpreted that the, what do you call that, pandemic situation or something,
Ground is not,
this should not present. Now, if you come to paragraph 21, in this paragraph 21,
Lordship.
state of Tamil Nadu case has been discussed
Lordship.
for subordinate legislation. Here again, you see,
C,
uh,
violation of any provision of
no, not that, D,
B, violation of fundamental rights granted under Constitution of India.
no, D
D,
for Delhi.
failure to conform to statute under which it has made extending the time of authority conferred by the enabling act.
So
Lordship,
if
here,
that situation is not there,
no, Lordship, there was a tradeway discussion, there was a different proposals. And ultimately, it was seen because lot of cases were pending during, due to COVID, Lordship. And
that thing is not available. There's a past backlog.
no, force majeure, Lordship, it has been, Lordship has seen the minutes. Here in paragraph 4.1, paragraph 3 of the minutes. Lordship may examine since many
You can
cases.
proceed with the matter, it will not be finalized.
Yes, Lord.
So D, Saraf, Learned Counsel for the petitioner. Mr. Chaudhary, you have anything to say?
No, here the.
You have adopted their.
Yes,
which also heard. You have for?
Taken with the appearing for resolution number 1 on behalf of the estimate.
Oh, okay, Mr.
Taken with.
KK Mehdi, appearing on behalf of SK Mehdi, Learned CGC for respondent number 1. Mr. V. Chaudhary, Learned Standing Counsel for the Finance Department, appearing for respondent numbers
2, 4 and 5.
2, 4 and 5. And Mr. S.C. Kyal, Learned Standing Counsel for CGST, appearing for respondent numbers 3, 6 and 7. By filing this repetition in Article 226 of the Constitution of India, the petitioner Mr. Saraf, there is an inherent defect in your writ petition.
Lordship.
There is an inherent defect in your writ petition. For a company, there cannot be a fundamental right. The Constitution bench has long back decided it. You cure that defect. Otherwise,
I will cure it, Lordship.
if it is heard in this bench, your petition will be dismissed in the
I
beginning.
will cure it, Lordship.
A company does not have fundamental right. The Constitution bench judgment.
I will cure it, Lordship.
The petitioner has said the notification number 9/2023 09/2023 dash capital CT dated 31/3/2023 by virtue of which
It's 32, Lordship.
the time limit provided under section 73 within bracket 10 of the CGST Act for the financial years 2017-18, 2018-19 and 2019-20 was respectively extended to 31 12/2023, 31/3/2024, and 36/2024. It is projected that the
Correspondent number 5.
that the time limit in respect of the petitioner for examining the annual return for the financial year 2017-18 had expired on
7th February 2020, Lordship.
7th February 2021,
2023, Lordship.
2023. However, on the strength of the appeal notification dated 31/3/2023, show cause notice was issued to the petitioner for the financial year 2017-18. And accordingly, the said notification has been challenged, inter alia, on the ground that the conditions precedent under which provision?
168A, Lordship.
168A. What is that 168A?
Explanation, Lordship.
It is under CGST rules.
CGST Act, Lordship. It says 168A, power of government to extend time limit.
Yes. The condition precedents provided in explanation to section 168A was not present on the date when the notification was issued. First off, it is submitted that various courts in the country are also insisting with the challenge similar to one made by the petitioner. Next, the learned standing counsel for the CGST has produced a copy of the agenda of 49th GST Council meeting held on 18/2/2023 with the relevant extracts of the agenda for 49 GST Council meeting held on 18 February 2023, proposing that the issue regarding extension of timelines under section 7310 was discussed threadbare, and recommendation was made for extension of time in view of the force majeure conditions that prevailed during the COVID period, where the employees of the office either could not attend the office or they were attending duties on staggered timing. This topic is submitted that consequently there was a huge pile up of the files for examination and issuance of process for recovery of tax not paid or short paid, or input tax credit wrongly availed or utilized during the said period. Accordingly, it is submitted that the issuance of show cause notice was fully justified, and therefore he opposes the admission of this writ petition. Next, the learned standing counsel for the state GST and finance department has submitted that the state GST had adopted the notification issued by the central government, and therefore the said notifications for extension of time applied on the state Topio Vigore, PROPIO VIGORA. Next paragraph. In view of the issue raised, that a notice returnable within how much time? Notice how much time will be to respond?
4 weeks.
The issue is returnable in 4 weeks. Requisite extra copies of the writ petition be served on the learned CGC and standing counsel for the respondents. Next, taking note of the fact that the similar issues have been examined by various courts of the country. The court is entitled to provide that while the respondent authorities proceed to examine the matter on the basis of proposed notice issues.
Pursuant to the notice, the order was also passed. So I pray for no coercive action, Lordship.
No, not coercive action. We say that they will not, and final orders passed will not be implemented.
Lordship, that would be enough. Oh, the adjudication has already been held. Lordship.
Where is that?
Lordship, it will be at page 46. The text will start from 51, the operative part.
Counsel for the petitioner has had at this stage has submitted that pursuant to the show cause notice, you participated there.
Lordship.
The petitioner participated in the proceedings, and final order.
29/12/23.
It is called final order in original.
Oh.
Yes.
The date only says order, Lordship. CGST authority says order in original.
Okay, the final order has been passed on
29/12/23.
29/12/2023. under such circumstances, when a final order has already been passed, the court is inclined to provide that till further orders of the court, the final order passed on 29
12/23, Lordship.
12/2023. What is the amount is 6,69,000,
Lordship,
320.
Lordship.
The
Finally tabulated at page 54, Lordship.
So, Mr. Sir, just tell us,
Lordship.
you want to pay the principal demand letter protest because otherwise your interest will continue to run.
Lordship, that would continue, but supposedly if the entire
No,
demand.
you will get, by the orders of the court, you will get a refund if required, because your interest would multiply. Out of 3 lakh rupees principal, your interest has come to 3,40,000.
Lordship, the problem will be that because this is.
No, you take your call, you see.
No, no, Lordship, no
Uh,
comment at this stage, Lordship.
Okay. Because I can't examine those things.
Lordship.
First of the till further orders of the court, the recovery of the amount assessed against the petitioner shall not be enforced. Because of that order, you give a date after 5 weeks. 10/5 will be okay. 10/5.
Okay, 10/19.
10/5. Okay, given a fixed date then. Same order in all the cases? I think
Lordship, there are difference in the year 17/18. In some of the cases, there is 18/19.
just write it and
So I
give it
will
to
write it down in a sheet.
give
and I will
it to
hand
my
it
court
over.
master.
In one case, Lordship, there is only show cause notice. That will be, no final order will be passed.
Show cause notice, etc. Then
They will participate.
the authorities shall proceed with the hearing on the show cause notice. However, no final order should be. No, and the final order passed shall not be enforced by further orders of the court.
Oblige, Lordship.
Mr. Kyal, you take back your document. Document you take back. Yes, no, Mr. Roy Choudhury, your matter.
Your Lordship, may look into the list of dates that I have provided.
Yes.
My lord, in the list of dates, your Lordship, with serial number 1, your Lordship will find the date that is 25/5/2017. That was the Board of Directors for the year 2017-18 to 21-22. Up to that period, so that was the election held on 25/5/2017. Now I take your Lordship to page 44 of the writ petition. Page 44. Your Lordship has got it, Annexure 8.
Yes.
My lord, the date is 39/2021, Thursday, following other discussion, resolution number 9. Lastly, after discussion on miscellaneous issue, the proposal of C. Abdul Latif that as per board meeting of 19/9/21, the order which was given to Arun Prasad to deal with the farmer payment, house electricity shall be given to Secretary Motilal De for such and such unanimously adopted in the meeting. Then, my lord, no resolution was adopted regarding handing over charge to the secretary form 10-10-21 as per resolution 9, and such the aforesaid resolution number 9 is cancelled unanimously. That was our annual general meeting held on 39-2021. My lord, then other pages are up to 55 is the vernaculars. Then, my lord, your lordship may turn to page 56. 56, my lord. The lordship has got it. This is the approval. Proceeding of the annual general meeting dated 39-21. It was previously adjourned on 22-9-21. With reference to I am to communicate herewith the approval observation of the proceeding of annual meeting election held on such and such. This was by the in charge assistant registrar of cooperative society. This was approval was given. And my lord, now your lordship may turn to page, my lord, 156. If your lordship, I will trouble your lordship to page 156. That is in the affidavit. 156. Affidavit in reply.
Yes.
Relevant is at page 157, resolution number 3. In the meeting, today's meeting, after discussion on the activities of Secretary Sri Motilal Dey, whom my senior friend is representing, Motilal Dey, it is seen that the society is suffering a lot. He is trying to destroy the society by stating his own mill business. Therefore, unanimously, it is decided to release Motilal Dey from the post of secretary. Presently, in lieu of secretary, he is entrusted the duties of supervisor, and in this condition to manage the affairs of the society. Sri Manik Gwala, member of the society, is appointed temporarily. The business of the society is to be managed by Manik Gwala as a presently managing Sri Arun Prasad Roy. Your lordship has seen this. This is now, your lordship, the up to page 161 at the vernaculars. My lord, then your lordship may turn to page 162. This is a notice to the respondent number 4, page 162. You have given 2 show cause notices 31-22 and 4-22, but you have not given any reply to the show cause notices. Now the society in its meeting dated 9-22 had decided to appoint you as a supervisor of the society in lieu of the secretary. That was the notice given to him, page 162 and 163. Now, my lord, your lordship may turn again to page 19 in the writ petition. I'm sorry that, my lord, I'm jumping over, but the sequences are as such, my lord. Page 19, my lord. That those issue what I have placed, my lord, that relates to the earlier board of directors. Your lordship has got it. That was up to 22. And earlier board of directors has taken a resolution that the AGM was approved, and they have taken a resolution. Their secretary will be removed from the post and he will be given as a supervisor because he has done some mischiefs and lot of misappropriation of the other things were there, and it was not good for the society. So he was removed by the earlier BOD. Now I take your lordship to page 19, 19, annexure 1. This is the notice. May I read it, my lord, slowly?
Just tell us, don't read that.
My lord,
Just tell us the contents.
the contents is this, my lord. My lord, the annual general meeting for the year 22-23 for election of directors of the said Samiti for the period of 22-23 to 2022-26-27. So this was for the period, this was a notice given for a new election of the board of directors from 2022 to 2027. It will be held on 17-4-22 for such and such general meeting to be held on such and such in such and such place. This was the notice given. Then, my lord, your lordship may turn to page 21.
Yes.
At my lord, this is the relevant portion. I have typed it out. Today's meeting fell requirement of an efficient secretary of the society, and accordingly, Sri Manik Gwala, dedicated farmer, is proposed by chairman, come president of the meeting, in place of ex-secretary Motilal De. A new person has been inducted as a secretary. As permanent secretary, by supporting the aforesaid proposal, Sri Abdul Latif, the meeting decided to appoint Manik Gwala as secretary of the society and entrusted the duties of the management of the society. It is mentioned that the meeting of the board of directors dated 9/2/22 has resolved to appoint Manik Gwala as secretary of the society temporarily. Today's meeting approved the same by appointing Manik Gwala permanently as secretary of the society. So a new person has been, Manik Gwala has come in place of the respondent number 4. And this was by the new board of directors who has approved. Previously, it was removed and temporarily he was appointed. And this was now Manik Gwala has been appointed permanently. This is at page 21, my lord. Relevant other page up to 33 are the my lord vernaculars. Then, my lord, your lordship may turn to page 33. Page 33, that is 2nd May 2022, Annexure 3.
Yes.
Page 33, my lord, now. This is, my lord, with reference to the subject cited above, I am to communicate here with the approval observation of the proceeding of annual general meeting held on 74/22 as follows, which I have shown you earlier, lordship, Annexure 1, page 19. This was new general meeting, the election was approved by the register. And 34 is the board, my lord. Your lordship will find at page 34, that was the board, my lord. Now I take page 35 is the original copy. Then, my lord, first meeting of the board held on page 36, your lordship will find. Page 36. First meeting of the board of directors, newly elected board of directors. Proceeding of the first, page 36, your lordship has got it. First meeting, proceeding of the first BOD meeting held on 8/5/22. I am to convey here with the approval observation on the proceeding of the BOD meeting of your society dated 8/5/22 as noted below. Selection, Abdul Latif chairman, vice chairman society thereby approved the provision such and such. So the new election was approved and the first meeting was also approved by the in charge assistant registrar of the cooperative society. My lord, next page, page 37, my lord, the respondent number 4, who was removed from the post of secretary, filed a complaint before the registrar. Allegation and complaint against the illegality done by Abdul Latif. He files a complaint. Date, my lord, the relevant date is 25/4/22. Your lordship, left-hand side bottom. The relevant date because the meeting and others has already held, and thereafter, my lord, a new body comes and he files a complaint. And on 25/4, the earlier meeting at page 19, it was held on, my lord, 17/4/22, and he files a complaint on 25/4/22. Your lordship has got it. After the new body comes over, he files a complaint before the assistant registrar. That is 25/4/22. Next, my lord, at page 38, he files it to the assistant registrar of cooperative societies, Karimganj.
Yes.
Page 38, he files another complaint to the assistant registrar of cooperative society. That is left-hand side. Again, the date is 27/4/22. These are all after the new body has come into, after elected and got approved. And the first body meeting was got also approved. On this complaint, my lord, notices were sent to the new body that is in one page 64, 164. My lord, that I will not trouble your lordship. Notices were sent to the BOD, new elected BOD, page 164. Now, my lord, your lordship will find page 62, 63. Is the order of the appeal, my lord. On an appeal petition filed by the respondent number 4, this is an appeal dated 10th August 2022. May I read the appeal, my lord? This is relevant. Page 62.
Just read the operative part.
Operative, because my lord, because my submission will be required, my lord, for subsequently in the review. Only few portions I will read it, my lord, at page 63.
Yes.
My lord, last but third paragraph.
Yes.
It also appears it is the only ex-secretary Motilal Dey, the appellant, your lordship has got it, appellant in the matter who could have manipulated and tampered with the cash book proceeding book since the same were in his custody. This was the finding given by the Motilal Dey, my lord. That means the respondent number 4. That was the finding. Your lordship has got it at page 63. This was the finding given by in the appeal, that he is the person who has manipulated, because the cash book and documents were with him. As regards the issue of appointment of removal of chief secretary such and such and such, having regard to the finding arrived at, as above, there is no substance in the allegation labeled in by the appellant against the chairman, Greater Badarpur, such and such, preferred by the Motilal Dey, former secretary of the society, accordingly dismissed. So the appeal was dismissed. My lord, he files a review in the next page. Page 64 is the review.
Yes.
Your lordship, in the review portion, in the review petition, my lord, prayer, what he says in the prayer is this: in view of the above submission, I request you to consider review petition and thereby set aside the order dated 4/8/22, further declare the BOD was dissolved null and void in terms of section 39 as stated above, and further direct the BOD to return back proceeding book and allow me to discharge my duty as secretary of the Cooperative Society. That was a different prayer in the review petition. Page 64A. Then, my lord, he approaches the Honorable High Court. High Court in the motion itself dispose of, directing the review petition to be disposed of within 4 months. That is at page 67, 68.
Yes.
Then, my lord, the order of the review comes at page 69, which was impugned before this honorable court. May I read it, my lord? It's slowly. Review under section 112 of the Assam Cooperative Society dated by Motilal Dey against the order dated admitting that as per Honorable Guwahati High Court and matter heard on such and such, again on such and such. Peruse the review petition where the petitioner requested to set aside the aforesaid order and declare the BOD of the such and such as dissolved, and further direct the BOD to return the proceeding book and allow him to discharge his duty as secretary of the society. The following persons were heard. The petitioner stated that the AGM election was held on 26/9/21, which has to be adjourned due to lack of quorum. Therefore, the adjourned meeting held on 3/10/21 and not on 30/9/21. That was their only crux, what they want to project. That manipulation is done here. 3/10/21 and not on 30/9/21. The chairman Abdul Latif insisted an adjourned meeting was held on 30/9/21. If the adjourned meeting was held on 3/10/21, that as per section 39 of the Assam Cooperative Society Act, the board automatically stands dissolved. On examination of the proceeding of the AGM of the year 2021, during the hearing, it was found to be tempered. The respondent stated that Motilal Dey manipulated and tampered with the proceeding as the record were in his custody, he being the secretary of the society at that point of time. The ARC Karimganj stated that the adjourned AGM was held on 30/9/21. The ARC was asked to ascertain as to who has submitted the proceeding of the AGM in the office of ARCS. But the ARCS was unable to ascertain the same. Hence, the responsibility of tampering the document rests on the person who has last signed the proceeding of the AGM. He totally substitute his own view. Earlier view was that, my lord, the documents were with Motilal De, who was tampered, and now he says, my lord, he has substituted his own view as a registered in a review application. That too not in an appeal, in a review. Unable to ascertain the same, and hence the responsibility of tampering the document rests on the person who has last signed the proceeding of the AGM. It has been found on examination of the proceeding of the annual general meeting that the aforesaid proceeding was last signed by the chairman of the society, Abdul Latif, after making some addition to the proceeding earlier signed by the chairman secretary of the society. Therefore, the approval of the proceeding of the AGM dated 9th October 21 hereby set aside, and the board of the society is to be constituted as per section 41(6) of the ACS Act. Malad, this of 9/10/21 is of the earlier board of directors. A new board has come already. And my lord, the ARC is directed to ensure that the proceeding of the annual general meeting was properly verified with the proceeding book of the society before receipt of the same in this office. Further, matter of allowing the petitioner Motilal De to discharge his duty is to be decided by the Board of Directors as per provision of 38(7) of the Assam Cooperative Societies Act 2007. He says nothing about the order of the appeal, neither he recalls the order, neither he set aside that appeal order, only he substitutes his view. Earlier he says that, my lord, that secretary is the custodian of the documents, so he has tampered and manipulated. Now in a review application, my lord, he substitutes his views and says the person who has last signed the document, last signed and the documents sent to ARC is the person who has tampered the documents. And he set aside the earlier, my lord, 9/10/21 board of proceeding of the AGM. And my lord, as regards, my lord, I need not place your lordship is well aware of, my lord, this judgment at, my lord, regarding, my lord, appeal in a review whether he can pass an order. My lord, I have marked from page para 15 onwards. My lord, I will write it here, para 15 onwards. My lord. That in a review it cannot substitute the views, my lord. Two things, my lord. The new board already election was held, approval was given. Now, my lord, when it becomes defunct, my lord, para 15 onwards, my lord, para 15 onwards.
This Peri Kansara,
Huh?
this case of Peri Kansara
My lord.
is on the power of review under CPC.
CPC. My lord, here the review concept of is the same, my lord. Review concept is the same. But here review cannot be a second appeal before the same authority. Review concept is same. Register, he takes a appeal and he passes an order. Then before him is the review. Because
No, you see, you can't find fault with that. The reason being there is a High Court order
no, no.
asking him to pass an order in review. So he has done it.
He passes the order, but he cannot substitute his own view. I mean, there is no wrong to pass an order of review. He has the authority to pass an order of review. But whether the principle of review, can he substitute his own view? Whether he has to find out error apparent on the face of record. What was the wrong done?
No,
And moreover, he has not recalled that order of appeal. He is every right. is
Mr.
there.
Rathore,
No, no.
you will have to explain it to me because you see, statute is interpreted on the basis of the language used in the provision.
Provision.
114 contains a particular provision. Please
No.
see that.
(114). Any appellate authority and the register in case of review may pass and stay order pending any appeal or review before such an authority, and may award cost against any party appealing or petitioning for review if such appeal or review petition is considered false, vexatious, frivolous, or authority concerned. And my lord, regarding review, it has said in number 3, save as otherwise provided in this act and rule, no appeal shall lie to the state government against any order of the registrar, except on a question of law, and provided such appeal is preferred within 60 days and communication of such order. Then comes the review. And my lord, here nothing has been said about what will be the power of review. Only thing that if it is frivolous, then there may be a cost. The what review, my lord, here,
Yes.
and that too, he has not cancelled the order of appeal. The order that was passed in appeal dismissing their petition and giving us different view, that was not set aside. Neither it was recalled.
Principle of merger would apply.
My lord,
Principle of merger would apply.
my lord. I have not got it, my lord, sorry.
Principle of margin.
The principle of merger would apply.
That will happen. Correct. That is also correct.
Because you see, when we are hearing the scope of review
My lord.
within the meaning of section 114, then we fall back upon the procedural part under order 47.
My lord,
Now this 47
my lord,
gives 3 reasons,
my lord.
out of which the last one, which is for any other sufficient reason, has been interpreted
My lord,
within 1 and 2.
my lord.
So the first two are again same as the substantive provision. Discovery of new and important matter, which after due diligence was not available.
Mm.
And then some error apparent on the face of record.
Record. But he cannot take up, my lord, the registrar cannot take up the review as an appeal, man. He is again taking up the, my lord, review as an appeal. To, my lord, to rewrite a judgment which has, by which the controversy has been finally decided. He was trying to rewrite a judgment, which was the controversy was finally decided. That power was not with him.
Let us see what Mr. Das says. Anything more you wanted to add?
My lord, after, my lord, if required, I will reply.
My lord, your lordship will kindly see section 49 of the Cooperative Act. The respondent number 4 is the secretary of the society, who is now chief executive.
But Mr. Das, please tell us if this, even if this 30/9/2021 is set aside, let us say that it is validly set aside.
Yes.
This order of the registrar is valid. Let us assume for the time being to set aside the order, the last AGM proceedings of 30/9/2021. But the subsequent AGM and the election, that stands, that has not been, that can't be thrown out.
Your lordship, in that case, my lord, there, I'm in a very weak position. That's what I was discussing with my learned friend. There, your lordship may give me, I think, liberty. Otherwise, my lord, review petition is because detecting fraud, man. When they detect it, may I just point out, my lord, what was the case about? I'll just not much take, my lord, to take time, because they are taking advantage of their own wrong now. What your lordship is said is correct, my lord. We should challenge it. Challenge that order along with this petition. This should be heard. Otherwise, my lord, what they have done is, my lord, they have taken advantage of their own wrong. I'll just place one matter, my lord. Section 49, that is the power of the chief executive. On the face of it, fraud has been committed. I'm just going to point out that. 49, this is the power of this secretary whom I am representing now. He was the secretary. And subsection 2, your lordship will come to all these powers, day-to-day management, operating the accounts of the cooperative society, signing on the documents, then convening meeting of the general body meeting of the society, the board and the executive meeting, all these, my lord, functions of the cooperative societies are there. Now, what was the problem is, my lord, page 62, your lordship may kindly see. Page 62. When the meeting was held, my lord, it is his duty to point out, so he filed an appeal. My lord, last paragraph, my lord. The contention of the petitioner, well, I'll just read briefly, my lord. Has your lordship got it?
Yes.
The contention of the petitioner is that the board of directors convened the AGM election of the society on 17/4/21 with an unauthorized secretary. That is different matter, personal matter, I'm not going. Manik Goala instead of himself, who was the legally appointed secretary of the society. According to the appellant, the annual general meeting was held with 436 voters, whereas the actual member is 400. Further, the appellant, this is the clause. Further, the appellant stated that the AGM election was held on 26/9/21, which had to be adjourned due to lack of quorum. Thereafter, the adjourned meeting was held on 3/10/21 and not on 30/9/21. As submitted by the board of directors, the plea was raised since unless the AGM was held on 30/9/21, the term of the board of directors would have lapsed. So, lapse. In this context, the photocopies of the records and documents of the societies were produced, and it was noticed that the records had been tampered with. The original copies of the records could not be produced by anyone. So this appeal order was passed without looking into the original records and taking into consideration the tampered documents, my lord, which has been held by the appellate authority himself. So ultimately, my lord,
Just a moment.
my lord. নিজের বুদ্ধি হইলো তো তুমি চ্যালেঞ্জ করতে পারবো না। My lord, your lordship, page 91. Page 91, the original is at page 92. This was the notice issued on 9/9/21 by the respondent number 4, man, as secretary, as per provision of law. Page 91, 92. Dated 9/9/91. This next, my lord, 93, my lord. Original is at page 94. 27/9/21. Adjourned meeting was fixed at 3/10/21. This is issued by the secretary. And now what they have shown is at page 21, 19. Page 19, your lordship will kindly see who has issued the notice. On the face of it, my lord, committing fraud, my lord, page 19. This notice was issued by the secretary. Where is his power, man? He is issued by the chairman. Now, page 97, your lordship will kindly see.
Just a moment.
এটি কি অরিজিনাল নাকি?
Page,
Page 97, my lord. That your lordship will kindly see that Homoy Bella 3921 Robibar. Has your lordship seen it? ma'am?
yes,
Homoy Bella Robibar, it is on, actually 3921 is Thursday.
is it?
Yes. I have given calendar, my lord. And what they have annexed. ওদেরটা কোনটা?
Good that you are maintaining this.
Page 44 one.
Good that you are.
Page 45 in our petition.
Yes. Page 45, my lord. Now they have, my lord, make it, my lord, Thursday. So now what the impugn order, I'll just read, my lord. Impugn order I can read from the petition and all from the appeal also. Page 71, my lord.
Page,
71, that is the impugn order. I will not read my lord, para 1, 2. My lord, last but my lord 3 from below. On examination of the proceedings of the AGM of the
please,
20
page,
71. It is there also in my affidavit that I am reading from. On examination of the proceedings of the AGM, has your lordship got it? On examination of the proceedings of the AGM of the year 2020-21, during the hearing, it was found to be tampering. The respondents stated that Motilal Dey manipulated and tampered with their proceedings as the records were in his custody, he being the secretary of the society. The ARC Karimganj stated that the adjourned AGM was held on 30/9/21. The ARCS was asked to ascertain as to who had submitted the proceedings of the AGM in the office of the ARCS. But the ARCS was unable to ascertain, very, very important, because the ARCS office, they are supposed to produce the proceedings. So, but the ARC was unable to ascertain the same, and hence the responsibility of tampering the document rests on the person who had last signed the proceedings of the AGM. The proceedings of the AGM was signed by the chairman. It has been found on examination of the proceedings of the annual general meeting that the aforesaid proceeding was last signed by the chairman of the society, Abdul Latif, after making some addition to the proceedings earlier signed by the chairman, society of the society. Well, this kind of findings, whether in review petition, in appeal, writ petition, your lordship will interfere. Finding of facts. Therefore, the approval of the proceedings of the aforesaid AGM by letter number so and so.
Normally the proceedings are retained by the secretary.
No, it is not there. That's why, my lord. The secretary has issued the notice. They have issued another notice. Secretary, as per the secretary, my lord, the meeting was held on 3/10. Adjourned. It was adjourned on 27. My lord, it was held on. Now they are saying it is held on 30. Tampered documents, my lord, and there is a
Where is the notice of the secretary? Please show us again.
secretary's notice at page, my lord, 91. First notice. There are two notices, my lord. This kind of, my lord, proceedings, I think, my lord, writ court will not interfere with the findings of the fact recorded in the review petition.
First notice is 91.
Yes. 91 issued by the secretary.
Yes.
93 also issued by the secretary. Page 91. And
Just a moment.
ठीक है, देखो सर 42 42 4921 9921, right? Are you okay? 49 yeah. Initial notice was on 4/9/21, madam. But the chairman said it may not be possible. So it was issued on 9/9/20. Second, 1044. That is chairman. Indicate, chairman. Tempered 44. Chairman. A 4/9/10. 4/9 was issued on 9/9. কোনটা? 44. 55.
Yes.
My lord, your lordship will kindly take page 42. 42. This notice was prepared, but this notice was not published. Page 42 by the respondent number 4. And it is stated in the affidavit. 4/9/21, this was prepared, but the chairman said, no, you should issue it on different dates. So accordingly, that 9/9/21 notice was issued. Now the tempered document is at page 44, man. Page 44, it is issued by the chairman. Minutes of the meeting. And page 55, your lordship will kindly see that additional part which was reflected in the review order. Page 55, that paragraph, last paragraph.
Meeting session with didn't have a different created one. Date has been different.
And page 55, your lordship will find that the date also is tempered. 39.
Just a moment. You're saying that this 22/9 meeting was adjourned and taken on 3/10,
3/10, yes.
correct?
Yes,
22/9 it was adjourned.
adjourned. 26/9,
26/9.
yes.
Where is the proceedings of 26/9? That is,
26, no, it was adjourned on 26, but again on notice was issued on 27/9/21. That
no,
your
where is
lordship
this,
will find
where is this 26/9?
20, page 93.
26/9 is 93.
That is 27, because 26/9, no meeting was held, so on the next date, man. The annual general meeting again will be held on 3/10/21.
just out of the 26/9. কনফিউশন করা যাবে না বিকজ এডজার্ন মিটিং 7 দিন পরে দিতে হবে তো 22 তারিখ বলে 30 তারিখ দেখাইতে পারে বাট 26/9 is
Okay.
So this is, now my lord, I'll just rely on two judgments in this court, because fraud, my lord, when the fraud has been detected by the court below, your lordship will not interfere in a writ petition. My lord, your lordship will kindly take 2001 4 SCC 478, paragraph 10, 17 and 18, man.
2000?
2001 4 SCC 4 SCC 478, para 10, 17 and 18.
Para?
4 SCC.
Para?
2001, para 10, 17 and 18. When a finding of facts, my lord, my submission would be, I'll be relying on that only. Finding of facts, it cannot be interfered in a review, my lord, in a writ proceeding. Unless vitiated by manifest error, my lord, or is patently perverse. May I give a hard copy, my lordship wants.
I have it. No, you can give that copy, it doesn't matter.
My lord.
Give that copy.
Unless vitiated or patently, my lord, perverse, the finding of facts recorded by an authority, my lord, it cannot be disturbed. Ultimately, my lord, they committed fraud, and that is the finding of the authority. Why should writ court interfere in the matter? Then 2017, 2 GLR, my lord, 286. Right, Lord.
2017,
2 GLR 286, para 12 to 16, my lord.
2 GLR page.
286. Para 12 to 16. What is the consequence of not holding the AGM on time? It gets dissolved. A person is officially appointed to hold the meeting. Para 12 to 16.
Yes.
So therefore, my submission is, my lord, when the authority is held, a fraud has been committed, documents has been tampered. My lord, my humble submission is that, my lord, your lordship in exercise of power under Article 226 will not interfere with this. Finding of facts, and on the basis of the record also, it substantiate the findings. Oblige.
My lord, if I can.
May please, your lordship. My lord, in the prayer, the order of review is under challenge. My lord. 1, 2. My lord, my submission is, my lord, the register has the power of review. Now, if your lordship comes to 111, my lord, 2,
Yes.
the language, my lord, is very clear. 111, 2, my lord.
Yes.
It reads, my lord, as follows. The register may review any order passed by him at any time within 60 days from the communication of such order. So, my lord, the power is wide enough, my lord. And my submission is the
May I take leave?
grounds of review, my lord, not enumerated under the statute. My lord, the grounds as applicable in under CPC, my lord, order 47, if I'm not correct, my lord, may not apply in respect of the review by the registrar. Because it says may review any order passed by. It does not, my lord, it does not qualify, my lord.
CPC also is almost similar.
My lord.
Only the qualification used is where order is appealable and no appeal is filed.
Right.
So only that is the restrictive language there. But whether the power to review, as assailed by Mr. Roy Chaudhary, is that in review, can he revisit his own decision?
My lord, my submission is, my lord, he is an administrative authority, man. So unlike a court, my lord, the procedure, my lord, under the CPC in respect of review by the administrative authority may not apply. Had it been a, my lord, tribunal or some other authority having the trappings of a court, my lord, this is my respectful submission, your lordship will consider. In this regard, my lord, if your lordship permits, my lord, I may find some authority also, the power of the registrar to review, my lord. How come, my lord, he will review? What will be the criteria or the, my lord, yardstick which will be applied? My lord. This is an area, my lord, which also requires, my lord, since an argument has come, my lord. And secondly, my lord, this is an administrative order. Your lordship will issue a certiorari. If your lordship finds it is patently illegal, or it is that perverse, my lord, which, my lord, in fact, it is irrational, not born out of records, or which shocks your lordship's conscience, my lord. The principles governing, my lord, the certiorari will apply in respect of an administrative order, my lord. But that is not the ground, my lord, which is taken in the writ petition. So the order passed, my lord, in the review by the registrar on 1/2/23, my lord, in my humble submission, it does not, my lord, suffer from any infirmity, calling for your lordship's interference, my lord. This is a reasoned order. And while passing the order, my lord, in fact, the registrar had complied with the principles of natural justice also. The parties were present. After hearing all the parties, my lord, the order under review has been passed. So in my humble submission, my lord, this order of review by the registrar, it does not suffer from any infirmity. This is my humble submission.
Yes, Mr. Roy Chaudhary.
May it please your lordship. My lord, first I will reply to my lord, my friends, Cooperative Societies Departments, Councils. Review, as he has said, is not of the same as the principle of CPC. My lord, in 111, the power has been given by if any government officer passes any order, in an appeal, the registrar will pass an order. If registrar passes an order, that attains a finality. He gives some finding on that basis. Here in this appeal, my lord, I take your lordship again to that appeal at page 62-63. 62-63. Against any government official, he passes an order. If anybody is aggrieved, file an appeal, he passes an order. And page 62-63, where the registrar passes an order saying it also appears that it is only the ex-secretary Motilal De, respondent number 4, the appellant in the matter who could have manipulated and tampered with the cash book proceeding, book, etc. since the same were in his custody. So that was the finding of facts arrived at. Finality arrived that he is in custody of all the documents. And whatever my learned senior friend has shown the documents, these were in his affidavit. This the custody, he was the custodian. He has tampered with all these documents. The issue before the register is who has tampered the documents. The finding was arrived at in the appeal that he is the custodian, he has tampered everything. Then, my lord, in review, he cannot rewrite the judgment as a whole. Then, my lord, it would have been the second appeal. That would have been a second appeal. That also, my lord, it should be on a substantial question of law. It cannot be a second appeal in the term of a review. The first appeal gives a finding that he is the custodian, he has tampered all the documents. That is why his appeal was dismissed. Now he comes and they say in a review that, my lord, that ARC has not been able to produce the documents. That is why the assistant registrar could not produce the document. That is why the person who has last signed it, he has tempered the documents. He cannot substitute his own views, my lord. In the same provision of in the statute, there cannot be two appeals. Then it would have been a second appeal if he can change the views. Why the word review? And the finding of facts arrived in the appeal is this: he is the custodian. And my lord, I am not directly saying that the same, but the provision of the word review itself, it shows even in a 226 application, my lord, if it is error or, my lord, if the whole issue is rewriting a judgment as a whole in a new, whether that was permissible before him. And I have come before this court in a certiorari because the power exercised by in the review is bad. The proceedings, the process adopted by the registrar in passing because the appeal was in my favor, it was against them. The process that he has adopted in rewriting a judgment, that is bad in law. That is why against that process, I have come before your lordship in a certiorari for quashing of that. And tampering and other things, my lord, that are before the registrar. Registrar will decide it, not by the writ court. It's a finding of fact. Correct, my lord. It was correctly said by my senior friend. It is the process, what has been adopted by the registrar in deciding in two judgments, one in appeal, one in review.
Okay.
That I raise my case, your honor.
But Mr. P.K. Roy Survey, counsel for the petitioner, also heard Mr. H.K. Talukdar, that is standing counsel for the Corporation Department, as well as Mr. B.D. Das, senior counsel, assisted by Mr. M.H. Laskar, counsel for the private respondent.
That's one number.
Expert. In connection with the submissions of the of the learned counsel for the petitioner, as well as the learned senior counsel for the private respondent is concluded. Mr. The learned standing counsel for the Corporation Department pays for some time to address the court on the extent of the power of review as provided in a section 111 within bracket 2 of the Cooperative Societies Act 2007. You can do it tomorrow,
Sometime.
Friday, because we can't adjourn it.
Yes, Friday, my lord, correct.
Friday, my lord, I had some difficulty, my lord.
He'll only give the question of law because I can't adjourn it.
My lord, what I'm trying to say, lordship has heard the matter. So extensively, lordship has heard only this point. So lordship will make it part heard. Can it be after Bihu so that I can
No.
find out some
No.
judgments, my lord, of other high courts also?
No. You see,
If
I'm not that brilliant to remember it after 15 days of
Let it be on
after
Tuesday.
vacation.
Let it be Tuesday, my lord.
No, not Tuesday. Tuesday we are very close to vacation. I'm not texting myself.
Thursday, then, my lord, this Thursday.
Thursday we have a different. There will be a change in. I'll be also heading a division bench. So
Then, my
not
lord,
Thursday,
Friday, then at 2 p.m. Friday at 2 p.m.
We both of you agree. I'm not fixing a time in my because this.
At 2 p.m. Friday at 2 p.m.
মই একো নাই, মই এতিয়া অলপ সময় পালে ভাল আছিল।
5 for 2024.
My lord, your lordship will keep it parted because otherwise if suddenly brain changes.
This was
Lordship has already heard the matter.
only on the power of review.
My lord, only on the
Limited
power.
to power of review,
My
not on.
In the, this state law, under this state law, Assam
No,
cooperative.
that we are not saying. Power
There
of
may be
review.
other perimeter provisions also in respect of.
There can be anything.
My lord,
Only on power review, no other factual matters will be open.
my lord, oblige. What is the?
Yes,
May please, your lordship. I understand that this petition can be disposed of in terms of my representation dated 3/3/2003 at annexure 12 at page 181. But if to narrate the facts, but I can tell your lordship that the petitioner is a company dealing in as a direct selling agent entity of different Ayurvedic products. And in that respect, my lord, there is a
but that is already banned.
pyramid scheme is banned.
Huh.
But if it is not a pyramid scheme, then it is not banned. Then your lordship may please to turn 144 at page. This is the rule made by the central government under the Consumer Protection Act.
Yes.
This is called direct selling agent, consumer protection, direct selling rules 2021 at page 144.
Yes.
A direct selling entity, your lordship may please to see rule 3D.
Yes.
Direct selling entity means principal entity which sells or offers to sell goods or services through direct seller, but does not include an entity which is engaged in pyramid scheme or money circulation scheme. Now, what is a pyramid scheme? Pyramid scheme is I at page 145. Pyramid scheme means a multi-layered network of subscribers to a scheme formed by the subscribers enrolling one or more subscribers in order to receive any benefit directly or indirectly as a result of enrollment of action or performance of additional subscribers to the scheme, in which the subscribers enrolling further subscribers occupy a higher position and the enrolled subscribers a lower position, resulting in a multi-layered network of subscribers with successive enrollment. This is prohibited. But if I sell it to the consumer directly, I am not prohibited. And your lordship please to see rule 11 at page 148. Oh, no. No, sorry. Rule 10 at page 150. Prohibition of pyramid scheme and money circulation scheme. No direct selling agent or direct seller will promote a pyramid scheme or enroll any person to such a scheme or participate in such arrangement in any manner whatsoever in the garb of doing direct selling business. Participated B, participate in a money circulation scheme in the garb of doing direct selling business. Now monitoring by the state government for ensuring compliance of these rules by direct selling entity and direct sellers, every state government shall set up a mechanism to monitor and supervise the activities of direct sellers and direct selling entity. I am, but the petitioners before your lordship is a company dealing in different Ayurvedic products and direct selling entity, but they don't subscribe to the pyramid scheme. They sell the product to the consumers themselves. And in that respect, your lordship may please to see at page 181, paragraph 2. Indus Viva carries its business in strict compliance with the consumer protection direct selling rules issued by the central government. But the state officials sometimes are creating trouble in the name that we are doing direct selling business or pyramid scheme or money circulation business. We are engaged in money circulating business. Therefore, we had filed a representation to the Director of Consumer Protection Act at page 181. That is our prayer, to make a scheme in terms of Rule 11 of the Direct Selling Rules 2021. At page 183, in the light of the above, we hereby request you kindly to indulge in a serious matter which affects many genuine and legitimate companies in Assam, and hereby request your honorable authority to act under Rule 11 of the Direct Selling Rules as issued by the Government of India, and in the alternative, modifications of circulars may be issued until a monitoring system is established in the state of Assam as per Rule 11 of the Consumer Protection Direct Selling Rules. This is my representation of the authority concerned, and this is my prayer in the writ petition. Page 23.
Page
Page
23.
23. This is my prayer in the writ petition.
But where is, where is any document to show that you have been criminally prosecuted
My lord,
in the
yeah,
state?
paragraph 17 and 18 at page 19.
No, but where is the prosecution? Where is a step issued by the government or any police to by which you can gather that you have been harassed?
Yes. FIR was lodged.
Where is that?
That is not annexed.
That is not annexed, of course.
And
But-
even then, there is no, my lord, that this regarding the direction, my lord, that my learned senior finance said, we have not, my lord, they made any scheme, my lord, regarding that. We are already communicated.
Where is that communication?
No, lordship, my lord, that we already been,
Page 180. No,
no,
not
lordship,
this.
so that. Well, actually, what I want to say, lordship, that whether there any scheme has been prepared by the, my lord, the state government or not, my lord, that instruction I don't have, my lord, right now.
Paragraph 17 of his lordship, well, paragraph 17 of the writ petition at page
Just,
19 may be seen.
Just a moment. Just a moment.
Which opportunity? Party election.
Just see this, with some assistance of
Yes, yes.
this is from the website
Oh, yes.
of your
Also
company.
procedure.
Now, on reading this, their policies, it appears that it's a multi-layered marketing company.
Yes,
It has not less than about 10 categories of sellers,
yes.
but it is, it's a pyramid system.
Pyramid
then.
system.
No. Subscriber enrolling further subscribers. That makes the pyramid.
Same thing is here.
No, they directly to the
No,
say
no. You see this,
terms and conditions.
you see, there is a system of VR, then VBO, then there is,
Yes.
then this category of
Direct-
silver, diamond, those categories are there.
VBO.
So there are not less than 10 categories of,
is
not less than 10 categories of subsellers. Once you have those category of subsellers, you fall within the pyramid. I think you take instructions.
yes.
Let us go through. What is it?
I mean,
These 6 pages, you can scroll up, go up,
পাবে
you can go up. The 6 pages of layering. You scroll up,
yes. Got it.
scroll up.
Because of that, my lord, that police has been, my lord, arrested and my
Right,
lord,
that's
that
what I will
a
say.
criminal
Yes.
case has been, my lord, pending.
You
Yes,
don't,
it is.
Das will not be,
Lordship.
read here is take instructions because you will not have instructions.
Whether
Huh?
direct selling entry rules, lordship, it is come on 21.
Then it also has that if you don't achieve a particular target, then you are downgraded to a lower category seller. It also has that if you don't achieve that target, then you are downgraded to a previous category seller. This is nothing but pyramid.
It is silent.
We'll find it out from the net.
Yes.
And then,
In the net, you type the name of the company.
yes.
You go back.
Right.
Now this is terms and policies.
Interview.
Then terms and policies, you click it, then. it comes up.
Oh.
No,
Let us go through. Let us go through this.
no, go through it. Let's say.
I don't know it.
No, it's okay. I have a bad habit. Uh,
After,
When do you want, Mr. Das?
after vacation, brother.
Choose a date, we give you that liberty.
This one, no.
25,
25th.
25 April.
What's his name, you go for it?
Thank you. মানে দুদিন আহিব নোৱাৰো।
Thursday.
Continue দুদিন।
Continue, I will.
Continue, right.
Both sides, including Mr. DC Das, senior counsel for the petitioner are present. The
Question is, I will
Plain
say-
Maybell and counsel, senior counsel for the petitioner, the matter stands adjourned today, this one 25/4/2024.
Watch it.
Internet. They can come back.
Yes.
Mr. Andy. I'm showing you a document. I'm showing you a document. It's a copy of Jamabandi where the Namjari is made by settlement officer, but in Assamese it is written Na Bo Pra. Bandobasta Adhikari, that means settlement officer, but what is the meaning of Na? It's not additional, it is not assistant. What would be Na? I'm just showing you the document.
I have to wanna look at my blend, then I can say it. Or I don't.
It is in black pencil. I have marked.
Lordship.
This is a judgment delivered last week, but because of this, I couldn't release it. There's only one thing I could not read. Bhopra is Bandobasta Pradhikari. That is okay, but what is Na? No, don't bother. If you don't know, then I'll write in my order as Na Bhopra.
And I already.
Oh, acha. I take up another matter then. Item 4.
Item 4.
May I please, Your Worship?
Yes.
May I please?
Yes.
Lordship, in this case, what happened, Your Lordship? The husband of the petitioner died in a motor vehicular accident on 26/4/2022, Your Lordship, under the jurisdiction of Bogribari Police Station, District Kokrajhar. And thereafter, Your Lordship, on
Okay, you got
24/3.
it?
Lordship, one. Whereas I have been received lordship, so that it is stated that my lord that some instruction they have been not received by the deputy commissioner, or so that my lord, he cannot, my lord, just send a proposal also. Lordship can dispose of this matter, my lordship can.
Just see your instructions. No, this would not do. That's why you see, you are creating trouble for yourself.
Lordship, as for a
You,
movement.
you see, this annexure 5.
Annexure 5, your lordship.
Annexure 5, you are sending it by registered post.
Yes,
The office says that they have not received it. If they have not received it, they can't do anything. So you see, you are applying for compensation. What is the harm in going to the office and getting it served there? You
Yes,
send by
lordship.
registered post.
Yes, lordship, register board, but the survey register board, but it till that has not been returned by your lordship. As per the General Cross Act, section 7, your lordship, if any documents sent by register boards and if not received, then it deemed to be paid sub.
Please read that section 27.
I am not received this. Your lordship.
You don't have
The
that.
meaning of the.
No. Yes. The requirement of law, we must understand the requirement of law.
Yes, sir.
General Process Act.
26.
Does it? General Process Act. नहीं जाते हो जाता है जी जनरल प्रोसेस एक्ट मतलब
Lordship.
where is the scheme?
At first 28, your lordship.
28.
Paragraph 3, your lordship. Serial number 3, your lordship.
Which column? Column?
Serial number 3, your lordship. Middle post.
We'll again direct you to submit your application
Lordship.
to the office, to the concerned office.
Yes, Lord.
The registered post business will not do.
Lordship.
That's why, my lord, that the deputy commissioner said that, my lord, that he has not received the, my lord, that.
And moreover, your
And
lordship,
even then, my lord, that the petitioner have to, my lord, submit along with, my lord, NOK certificate.
annex with representation. Enclosed with representation.
Heard Mr.
SI.
S.I. Akan, counsel for the petitioner, and also Mr. J. Andy Leonard, government advocate appearing for
Rest number 3, 4, 5,
3,
and
4, 5. You are additional senior government, no,
No, I am on the junior government.
government advocate. You are government advocate for the respondent numbers 3 to 6
3 to 6, lord.
and
And for 1 and 2, my
One, only one.
Miss
one,
P,
one.
P, Miss P.R. Manto,
Yeah.
then I counsel for respondent number 1 and 2,
my lord. 1, my lord.
only one. Standing counsel for respondent number
I am respondent to the
1. RM
Barwa.
Barwa. Standing counsel for respondent number 2. Next. The case of the petitioner is that her husband, namely late Rotin Chandra Barman, had died in a road traffic accident which took place on 26/4/2022 at about 12:30 p.m. It's projected that it was a hit and run case. Which occurred
Not hit and run, your
on
lordship.
it was not hit and run.
No, lordship, for asgracia.
My lord, he want to cross the, my lord, that roads, my lord. Suddenly, my lord, one motorcycle came and, my lord, he was, my lord.
What is the number of motorcycle? I have read somewhere that the
unknown
motorcycle was not untraced.
Yes, lord.
Motorcycle is unknown.
So that is not hit and run. Then
No.
what is what is it called?
That is asgracia claim. Our claim is asgracia, for asgracia, your lordship, as per the notification, government notification.
Plain.
Yeah, John, it.
Sorry.
If that is not hit and run, then I'm sorry, I'm wasting my time. Matters to John today,
Is the hit and run.
list in the next week.
Lordship, can I produce some order passed by the honorable God?
I'm not going to pass an order.
Lordship.
When you have disturbed the dictation by saying that it is not hit and run, when somebody hits a man in the street and the motorcycle cannot be caught, you still say it is not hit and run.
Lordship.
No, you have to learn a lot of things. And then explain it to us, because I am very sorry, I do not know the meaning of hit and run. If I don't know the meaning of hit and run, I am, it is good that I am not passing an order,
Lordship. I'm apologize.
correct?
Lordship.
Without knowing, if I pass an order, I will be doing injustice. So therefore, I can't commit an injustice. Knowingly, I can't commit an
apologize.
injustice. By ignorance, I can do it. But knowingly, I can't do it. Correct?
Sideways.
So John.
Lordship. Deep level.
Item 5.
Yes.
Five.
Lordship, I'm appearing on behalf of SC person, Mr. Viras, Lordship. Lordship, kindly allow some time to file affidavit in opposition, Lordship.
Not the same pair.
You are appearing for?
SC person, Mr. Viras.
You've seen the last order?
Lordship, today we received a signed copy of the affidavit in opposition, Lordship.
You received it?
Yes, Lordship.
Okay.
As in file for you. Not only.
You're filing it by when? We'll take it up on Friday then? Okay. You're taking it on Friday?
Mal. Some
Or-
urgency is there.
or
because
outside the represented. The standing counsel for the Cooperation Department has submitted that a signed affidavit in opposition is received on behalf of respondent numbers 1 to 7. And he prays for something to file it. And we'll be filing it. We'll be filing it shortly. You know the meaning of the order? Do you understand the meaning of the order? I've only dictated one line. I've said that you have received signed copy of the affidavit and you will be filing it. Do you understand the meaning of the order? No, don't search there. I'm speaking before you. Don't search for meaning elsewhere. Do you know the meaning of the order till now, which I have dictated? Have you understood the implication of the order?
So we have to file the affidavit.
Your affidavit will be a trash. It will be nothing more than a piece of paper fit for a dustbin. You can't have a signed document and then present it for presentation. It will be illegal. Your deponent has to come before the court and sign it.
Lordship, actually, we have to receive it from Hatsing, my Lordship.
Always take care when you speak. We will put you in a lot of trouble.
Lordship.
You can't do it. You will show us a copy which you have with you. As it is open. Correct. It will be a dustbin.
That can be
waste
done
paper.
when the notaris there. That notaris can be done there in Hachingmari and thereafter they can send it.
First of all, while filing the affidavit, the respondent shall ensure that the deponent is present before the oath commissioner of this court or notary public. Full stop. Based on 8/4/2024. Always take care when you are making statement. It may
Yes.
lead you to
I
a lot of
apologize,
problems. It will lead to a lot of problems.
Month on 8.
8th,
Month.
filing shall be done within March. The date.
Item 6.
Yes.
My lord, here is the case is that, my lord, the respondent number 7, my lord, who was ceased to be president, my lord, that your lordship will see at page 36, man. And lordship kindly.
Page,
Page 36. Annexure 8, my lord, lordship, kindly have a look the date, my lord, 15 June 23. May I read, my lord, small paragraph? With reference
just
to,
tell us what is that?
my lord, and on that day, my lord, the respondent number 7, he ceased to be president, my lord. He could not have called for any meeting or any adverse remark against me, my lord.
On what basis you are saying that?
That, my lord, lordship will see, page 36, second paragraph, my lord.
Yes.
Second paragraph, but the chairman took no action to the special meeting, so court bearing number so and whenever court passed an order holding that the special general meeting accordingly as per the section 43 Anu ceased to be chairman of the board of director under Samavai Samiti.
Correct.
That order was interfered, my lord, by page 60 before coming to the impugn, my lord. And
Yes.
that is the date, my lord, 2011-23.
Yes.
That order was set aside, my lord. In between that period, my lord, he cannot hold any AGM or he cannot call for a notice for holding meeting, my lord. Now, lordship will see he has called a meeting, my lord, at page 43, my lord. During that period, he was not a chairman at all.
No, it's a post facto validation. Once he becomes the chairman, by virtue of the order passed by the Registrar of Cooperative Societies, he restores, his position is restored back
My
ante.
lord, during that period,
It will be ante.
during that period,
No, he can't. At least that is what I think, unless you show us an authority on the point. You see, you say that X is not the chairman.
he was not, my lord, he has been
It's
seized
okay.
off.
But the authority who's competent holds that he was the chairman. So it is validated. It's expect back to validation.
Anyway, my lord, that aspect, my lord, I'll come, my lord. From the impugn order, lordship will see page 60, my lord.
Page 60, yes.
Yes, 60, last paragraph, my lord. In view of the above so-and-so Cooperative Society Assam Chairman General Meeting held on so-and-so, the chairman of the authorities are found to be valid. An order passed by the so-and-so and letter dated so-and-so is hereby set aside. Further, the decision, lordship kindly read this one. Further, the decision for appointing a permanent secretary of the society is entrusted on the board of director of the society. He said, my lord. Now, lordship kindly turn to my additional affidavit, which I have filed, my lord.
Now you just tell us what is pending before this court.
Pending, my lord, that is relating to the service side removal of the secretaryship. That is the service.
Removal of the secretary. Who is the secretary?
Secretary is the writ petitioner.
Okay.
Now, lordship will see for a moment, my lord.
Just now. Page 43.
My lord, before coming to that, my lord, I like to draw lordship's attention at page 65, which will be available at additional affidavit.
Page
65, my lord.
65.
65. It is on my approach, my lord.
Yes.
Heard the petitioner and peruse the relevant records produced by the petitioner and nature of the petition related to the demanding money by the president, that is the response number 7, from the secretary, which is a criminal nature. Undersigned does not have any authority to decide the matter related to the criminal nature. Hence, the petitioner may approach the authority. Regarding the suspension, dismissal, Secretary of Board of Directors may proceed as per the finding inquiry report conducted by the Food and Consumer Affairs Department. They said, my lord, in that, my lord, whatever finding has been there, my lord, they have to go on that, my lord. That point I'm coming, my lord. Then subsequent page, my lord, that is they have hold an AGM, my lord, on 8/23, my lord, page
Just a moment.
66.
Yes, page.
And now, my lord, lordship will see page 28, my lord, that is the minutes. Why, my lord, I am compelled to challenge the minutes before your lordship, my lord. Page 29 is the operative portion, my lord, resolution. In today's meeting, it is held.
Minutes, can it be challenged in a writ petition?
My lord, I have already gone there, my lord. I have filed my appeal, and he said, my lord, due to my lord, he demanding money, as per the report of that, it will proceed, my lord. Otherwise, now, my lord, I have no option. Because, my lord, the moment I have appeared, filed an
But
appeal
if that
150.
is the case, if you are challenging the minutes of the meetings in the
Ma-
writ petition,
My lord.
it's we disputed questions we can't adjudicate.
No,
We
my
have
lord,
to
only
close it.
simple is that, my lord, I have already approached.
You see,
100
please show us,
115.
you see, for the parameters of 226, please show us that they are performing a public duty. And then this, resolution is in discharge of such public duty, and it affects the, it affects the administration of justice. Because if you are agreed by the minutes, then there are authorities under the act.
My
If we
lord,
take over
under the
everything,
authority, my lord, 115, we have approached before the Registrar Cooperative Society. He said, my lord, the action will be initiated as per the inquiry report by that, my lord. And after minutes, my lord, it is found nothing against me, my lord. Let them bring on to record, my lord, what is the finding of that, my lord. That will resolve everything.
let us see your prayer first.
Prayer lordship will see at page 16 operative part, my lord.
2011-23, where is that order?
2011,
61.
23, page 60. Page 60.
60.
Yeah, my lord, agree because of my lord, he appoint for permanent secretary of the entrusted society. He cannot say so.
Yes, okay. Yes,
Yeah, my lord, lordship has seen, my lord. Once he said, my lord, that my lord cannot be because it is the amounts to my lord criminal actions demanding money cannot be taken away. Then my lord, he once again, my lord, he said the register that permanent secretary to be entrusted on the board of directors of the society. My lord. That affected me, my lord. Because there cannot be two versions. Because my lord, immediately on my suspension, my lord, and on the gelation that my lord, the president response number 7 was demanding money, my lord. I made a complaint under 115 of the Cooperative Society Act, my lord. Then the order has been passed, which I brought, my lord, to the knowledge of the court by an additional affidavit, my lord. Now, my lord, this impine order has affected me, my lord, because he is saying to board of director has been asked to, my lord, permanent secretary, my lord. I was there, my lord. If the suspension, nothing has been found, my lord, I'll be a fish like out of water, my lord. Nowhere cannot go. And that report, my lord, it is, if your lordship kindly see for a moment, page 37, my lord. The minors, they have found nothing
whenever you use
against
the word fish, I always smell something fishy.
my lord. Fishy,
Had
my
it been something else, you don't smell fishy, but this word,
What, my lord, what to say, my lord, because, my lord, he has
no, I don't
approached.
know, it's my way of understanding, but if you use the word fish,
Plus,
I always smell anything fishy.
yeah, my lord, then lordship will see in the minors, they have nothing, my lord. If the department comes up with a, my lord, what is the inquiry report? My lord? And
No, you see, your challenge is page 60.
my lord,
So we'll adjudicate on that, whatever their material is there in the inquiry report and all those things. For that, you have already challenged WPC 2413.
that is the
So we can't have
relating his
two
remove.
adjudication.
That is the remove. Now, my lord, the
No,
court
no,
issue is
no,
that,
no,
my
no.
lord.
When I'm saying something, and I'm very serious about it. Because if you are, if anything regarding your challenge to your secretaryship,
No, my lord, that is the independent writ petition is there.
no, then you choose your words. You see, please have a choice of words. Number one, if in this writ petition anything touches on your secretaryship, then we wash off our hands. I have two ways to do it.
Yes, my lord, it will
Correct.
touch. One
Now-
on the other, it will touch.
So, so that holds that if you are challenging page 60, then we are hearing you. But if you are using this writ petition as a collateral challenge to your removal as secretaryship, then we will not be that.
My lord, that writ petition,
what
I
you
am
call,
not the lawyer on that case. my
in the modern language, you call it the smiling emojis.
lord. Yes.
Correct.
Or can it be, my lord, lordship push the matter on Friday, my lord? I'll go through that.
No, not Friday. Now it goes after vacation. I can't tax myself
Lordship.
so hard.
I'll just go through that, my lord. What is the subject matter of that writ petition?
No, it's not even required. You see, if we have accepted a brief without knowing what is going on in other writ petition, we have done it with the at the risk and cost of the petitioner.
No, my lord.
Number
In the
one,
midway,
that's
my
why-
lord, some other
No,
lawyer
no,
was
no,
there.
no. Who may be a lawyer? We are not concerned with that. But the issue is that you should take instructions beforehand, not at the beginning of hearing. The second point is that we assume that when you are making a statement at the bar, the WPC 2413 or 23 is to challenge your removal of your secretaryship. We take it for that. We don't need any record for that. We take word of the
Yes,
officer of the
yes.
court at its face value. So if that is there, you have no other choice but to exclude your submissions on touching upon the secretary. We can only independently examine page 60 order. So that is the contours in which you can proceed.
Page 60, my lord, only last line it will affect. Otherwise, my lord, all these things are by board of directors. Last line in the sense, my lord, if your lordship permit me
Yes, yes,
to
please.
show, my lord, the permanent secretary, he is asking one way, my lord, permanent secretary. And on the other hand, he said, my lord, in the affidavit which I have shown, my lord, that your lordship will see, it is been said, my lord, that he cannot act upon because of the reason, my lord. Or can it be like this, my lord? I'll file a fresh representation before the registerment, enclosing all the things, my lord. Let be disposed of by passing a speaking order, my lord. That will
No, no,
solve the problem.
If you're withdrawing it, you don't need a liberty of the court. We can,
Or
because
lordship
you
fix
see,
the-
in this case, the reason for stopping is that when you are making me read page 60 order, we can at best pass an order to the effect that this decision of 2011-2023 would be subject to whatever decision is passed in 2413. So
That
that
has been
challenge,
taken care of, my lord. in
that
the
has been
interim
taken
order.
care of.
Yes, ma'am.
Where is that?
In my affidavit. In my affidavit, lordship kindly see. While rejecting his prayer,
Page.
page, my lord, 119.
119.
Last part, my lord, at 120. 120, my lord. The observation made in the imping order dated 2011-2023 by the respondent number 2, whereby the decision for appointing a permanent secretary of the society has been entrusted on the board of directors of the society, does not require any interference at this stage, and any appointment made in terms of imping order dated 2011-2023 would be subject to the outcome of the writ petition.
This order also shows that your present writ petition has to be dismissed in limine. Your, in that language by this court, the words used are impugned order dated 2011. So 2011 cannot be impugned in two writ petitions.
My lord, that's why, my lord, I want to see that writ petition.
No, this order of the court is sacrosanct. You have to respect this order.
My lord, I respect, my lord. This 2011, my lord, this cannot be impugned in that writ petition.
We don't know, but this is the language used.
In the present writ petition, my lord. This order is passed in the present writ petition.
Oh, this is in the present writ petition.
Present.
Oh, acha.
And my lord, he is not the secretary. That
No,
also,
then we make this absolute.
he is not
This
the secretary.
23 would be absolute.
Yes.
Whatever order is passed here,
Yes.
in your this what you call, you will not be prejudiced by whatever order is passed in this 2011-2023 when this writ petition WPC 2413 or 23 decided.
Yes, that would.
Heard. Mr. J.I. Barbunier, and counsel for the petitioner. Mr. Sarudar,
Yes.
you have anything more to say?
No, my lord, in fact, today I have received one affidavit. In fact, my lord, I have nothing to say, but what I find from this writ petition, it only relates to the AGM. My lord, essentially what has been done, my lord, the validity of the AGM has been challenged by a person who is no more in the society, rightly or wrongly. Let us, my lord, take it for granted for this time being. So the question is, my lord, whether on that count, the writ petition is maintainable at all. And my lord, the registrar has passed the order on the ground that the DRCS, when the writ petition was pending, DRCS has asked, my lord, the board to, my lord, hold a meeting, which he was without jurisdiction. He could not have done that. Writ petition was pending therein, my lord. And on that count, the registrar had said that DRCS, deputy registrar, is without jurisdiction. And that is the findings, my lord, in the impugned order. So if your lordship says, my lord, that these findings will subject to outcome of that writ petition, that may, my lord, perhaps become conflicting, because here the subject matter is totally different. Here it is only in respect of the AGM.
No. You
But
see,
so far as
no,
the
no.
last line is
Last
concerned,
two
lordship,
lines.
yes, lordship may make it clear, the last part.
Last two lines.
Yes,
That
correct.
is the only thing which
Correct,
is affecting him.
correct. And in fact, my lord, what I find, the registrar, my lord, has not directed anything. He said the board will take a decision. And under the statute, that is the board, my lord, who is empowered. So otherwise also, it's not prejudicial to the petitioner, my lord.
No, it is, because you see that it is, then if it does not challenge it,
Yes.
then his,
Correct.
is ouster
Correct.
and the appointment of permanent
Yes, yes.
secretary.
That will also be
becomes a
clarified,
permanent.
my lord. Correct.
That's the only reason.
Correct.
Also, Mr. S.K. Talukdar, standing counsel for the Corporation Department, representing respondent numbers 1 to 6.
My lord.
Uh,
Except 4, my lord. 4 is the district commissioner who I cannot represent.
1, 2, 3, 5, and 6. And for government, you will be appearing, and Mr. J. Henry Clerk, government advocate, appearing for respondent number 4, and Mr. J.M.A. Chaudhary, learned counsel, appearing for the respondent number 7. Next paragraph. By filing this writ petition under Article 226 of the Constitution of India, the petitioner has made the following 4 prayers. Page 16. Next paragraph. In brief, the case of the petitioner is that the respondent number 7 had ceased to be the chairman of Uttar Baguri Bari, BAGURIBARI, Baguri Bari, Samavay Samiti Limited. The operation of section 43 within bracket 3 of the Assam Cooperative Societies Act, 2007. However, nonetheless, the respondent number 7 had presided over an executive meeting held on 30/7/2023 and also held the annual general meeting of the said society on 23/8/2023. The petitioner claims the executive meeting as well as the AGM to be illegal. It is projected that although the illegal activities of respondent number 7 was reported to the respondent authorities, no action was taken, and therefore the petitioner had filed a writ petition before this court, which was registered as WPC 6290 of 2023. You have a copy of that writ petition? 6290, you have a copy of that writ petition?
No, man.
No.
Order is at page 57, my lord.
57 it is there. Operative part, lordship will see page 59.
Next paragraph. Next paragraph. This court by order dated 19/10/2023 passed in WPC 6290 of 2023 directed the Registrar of Cooperative Societies, Assam, to dispose of the appeal filed by the petitioner within 6 weeks. Full stop. Consequently, the two appeals filed by the respondent number 7 and appeal filed by the you just said by the 7 on 10/5/2023 and 17/6/2023, and the appeal filed by the petitioner on 16/8/2023 were taken up together. And the hearing was conducted in the presence of parties as well as other authorities mentioned in the order. Full stop. By the order dated 20/11/2023, the Registrar of Cooperative Societies opined that the annual general meeting public election held on 28/8/2023 under the chairmanship of respondent number 7 was found to be valid, and accordingly the order passed by the DRCS Borpeta on 15/6/2023 Where is this order?
Page 36.
No, 36 is the communication. In this page 20, page 60, there are two things stated.
My lord.
Borpeta wide number so and so.
My lord.
Where is this order? 31. 358/2022/31.
358, my lord, CBDA 2024, and that my lord, lordship will see serial number is telling at page 36.
Page 36, my lord.
No, 36 is page, no, serial number is 40.
40.
My lord,
I'll check that.
how to be.
In fact, this is the order by which it says that the district registrar says, my lord, the respondent 7 ceased to be the chairman. So
No,
this
you
is the
see-
order which was
you
set
see,
aside.
Come to page 16. Page
My lord.
50, there is, the authority is making two reference.
Oh, my lord.
Order passed by DRCS wide number so and so, 31.
Yes.
30.
And letter number 40.
Yes, 31 is also there, my lord. Page 35.
Page 35.
35, 36, both are there.
My lords.
Page 35.
Also, order dated 4/5/2023 and letter dated 15/6/2023 were set aside. And further direction was issued to the effect that the decision for appointing a permanent secretary for the society is entrusted on the board of directors of the society. Next, agreed by the said order dated 20/11/2023, the present writ petition has been filed. So the prayers made are already reflected above. Next one. The learned counsel for the petitioner has submitted that the appointment of that by virtue of order dated 15/6/2023, comma, the letter dated, not order, letter dated, sorry. Comma, the respondent was 7 was seized of his chairmanship of the board of directors of the Uttar Baguri Bari Samavaya Samiti Limited, and therefore on and from 15/6/2023 till the impugned order was passed on 2011/2023, or the respondent was 7 could not have acted as a chairman of the said society. And accordingly, it is submitted that the actions taken during those period by the respondent was 7 is illegal. It is also submitted that the petitioner is prejudiced by direction allowing the board of directors to take a decision for appointing a permanent secretary. So in this regard, it is submitted that the previously filed WPC 2413 of 2023 to assail his removal as the secretary would become infructuous. Next paragraph. Per contract, comma, the learned standing counsel for the Corporation Department has submitted that under the scheme of the Assam Cooperative Societies Act, 2007, it is the board of directors of a society which is otherwise competent to take any decision for appointment of a permanent secretary. Full stop. Accordingly, submitted that as the petitioner has already filed WPC 2413 of 2023, his interest is otherwise protected. Next paragraph. Per contract, the learned counsel for respondent was 7 has referred to the affidavit in opposition filed by the petitioner, and it is submitted that in this writ petition, an order was passed on 8/12/2023 whereby the interest of the petitioner was protected by observing that the appointment made in terms of impugned order dated 2011/2023 would be subject to outcome of the writ petition. Next paragraph. insofar as the challenge to the AGM held on 23/8/2023 is concerned, which is the prayer number 2 and 3 made in the writ petition. The court is disinclined to accept the challenge to the said proceedings of AGM held on 23/8/2023. As challenge to the proceedings is required to be made before the authorities under the under the Assam Cooperative Societies Act, 2007. So the court would because this would lead to disputed questions of fact. Stop. Moreover, comma. The minutes of the AGM held on 23/8/2023 appears to have been approved by the impugn order dated 20/11/2023 passed by the Registrar of Cooperative Societies, Assam, in view of the observations made that observation made in the order that it has that the said authority had taken cognizance of the AGM held on 28/8/2023.
It should be 23, madam.
Pardon me?
As part of the prayer, it should be 23.
23 years.
23/8.
No. I am reading 115. It is 28/8. Is a mistake.
I think.
Second last paragraph.
No, madam.
AGM was held on 28/8/23.
This may be mistaken. 28, 23, no? 23. He will know, madam. He will know the board. As part the notice also, it is 23, madam, page 38.
28, 28. Right in the bracket. Stop. It may be mentioned herein that in the prayer made in the writ petition, as well as in the which page?
It is, notice is at page 38, ma'am. Type copy, it
As well
indicates
as
that.
in copy of the notice within bracket annexure 9.
Yes, annexure.
The date of AGM is stated to be 23/8/2023. Therefore, in this regard, the court is inclined to relegate the petitioner to challenge the AGM in an appropriate manner as provided under the Assam Cooperative Societies Act of 2007. Next paragraph. Insofar as the directions contained in the impugn order dated 2011-2023 is concerned, wherein that part of the order, that part of the order is concerned, wherein it has been provided that the decision for appointing a permanent secretary for the society is entrusted on the board of directors of the society. The court is of the considered opinion that the factual position with regard to the Uttar Baguri Bari Samvay Samiti Limited is that the petitioner has been removed from the post of permanent secretary of the society.
Suspended.
Oh, sorry, suspended.
My lord, he's removed not from permanent, he's acting as secretary, he's the employee of the society as per his appointment.
So
Lordship,
what is his position right now?
right now, he's removed.
He's removed means terminated or
Removed from permanent, removed from this,
permanent removed?
removed. By resolution of the, my lord, board.
Okay, is permanently removed by resolution of the board. And the removal is the subject matter of challenge by the petitioner in WBC 2413 of 2023. First of, under such factual metrics, we cannot find fault with the entrustment given to the board for appointment of a secretary for the society. First of, however, in view of the challenge to the removal, in subjudice in WBC 2413 of 2023, the court is intended to provide that the secretary, if any, appointed by the board of directors of Baguribari, Uttar Baguribari Samavati Limited, would not be permanent, and such appointment would be subject to the outcome of WPC 2413 of 2023. First off, this observation is made so as to prevent any contradictory or conflicting orders to come on board, come on record. Next one. Accordingly, it is clarified that the order number, page 115, order number dated 2011-2023, insofar as it contains the direction allowing entrustment to the board of directors of the society for appointment of permanent secretary is made subject to final decision that may be subject to adjudication in WPC 2413 of 2023. The replacement stands disposed of accordingly. You've seen that?
Lord, if I have seen, I have entered, my lord. None of the officers cannot say, my lord, what is the meaning of na. It should be, my lord, assistant settlement officer should be it.
Assistant is
This is the typing, my lordship. Might be in the typing error.
We can't say.
Nah, my lordship, they cannot.
No, I did not find. That's why. Last 5 days, I have not been, 4 days, I have not been able to release this judgment because of, I pronounced it in the open court, but I thought that it would be very simple to find out English of na, but I could not.
It should be a ho. That
Huh?
ho
Okay.
should.
Maybe you are right. Yeah, given back. And continue. I may be 5 minutes late in coming again.
May it please your lordship. Well, there is a matter that pertains to bench 5. Actually, we thought it is a bench 4 matter we mentioned in the morning before court number 4. Then the court itself said it's a bench 5 matter, better mentioned before court 5. By the time 10:30 was over. Well, a matter where a PSO has been withdrawn without following the due process of law. Tomorrow, my lord. Deep look.
Supply item 25 for admission.
Your Lordship, Senior Counsel Viditas is online. Your Lordship, may kindly pass over the matter for the time being.
Time being.
Yes, yes,
Time
Lordship.
being.
Yes, Lordship. Objection.
Seven with 8 for orders.
Maybe. Well, item number 7 is my lord for contempt, my lord. They have not complied with the order.
What is the order?
My lord, order was for direction to the respondent for depositing the money of compensation with the deputy commissioner, my lord. The railway has not deposited the, my lord, that amount. Order dated 9/9/2022.
Page.
Page, my lord, 18 to 14. Relevant portion is, my lord. Page 40, my lord. Page 40, para 7.
Page 40.
My lord, 40.
Yes.
Made it.
Yes, okay.
Okay.
Yes, Mr. Gupta.
My lord, in the contempt petition, my lord, there was an order to list the same along with the review petition, my lord. We have filed a review petition, my lord, against that order. So review is also tagged together, my lord, today. There is an order in the contempt petition, my lord, to list it along with the review petition. My lord may take up the review petition first.
My lord, item number 8 is review, my lord. My lord, prior to review, they file a writ appeal, my lord. But this order is, my lord, with the consent of the parties, my lord. So the appeal was withdrawn by my lord friend and review was filed. But my lord, if your lordship may see that with review, even review is also not maintained because, my lord, they are taking the ground that they have taken some ground, my lord, that if it is.
It's okay, let him start.
My lord.
Then we'll come to it.
My lord.
My lord, before filing the review, my lord, we have approached the division bench, my lord, to challenge the order. And my lord, that order is at page 197
Of the review petition.
of the review petition. Page 197, my lord, heard so appearing for the applicant prays for withdrawal of this writ appeal with liberty to file a review application. My lord, in the writ appeal, the basic ground for challenge was that, my lord, the railway cannot pay compensation for the government land. My lord, the basic facts of the case was that, my lord, certain landowners, my lord, they were occupying patta land as well as government land, my lord, and on that particular land, my lord, a railway project was, my lord, to be constructed.
Yes.
And my lord, after that, my lord, in respect of few of the landowners, my lord, the railway has paid them, my lord, the compensation in the form of lease charges, my lord. There was no land acquisition carried out in the present case, my lord. The lands were occupied, my lord, for a temporary purpose by the railway for construction of the service road. And my lord, therefore,
Road is temporary.
temporary. And so, my lord, in respect of 53 landowners, my lord, we paid the lease charges and the land was returned to them. And thereafter, my lord, around 153 new persons again filed the writ petition, my lord, after 12 years, saying that they are also entitled to the compensation. Now, that was the background, my lord, in which the writ petition was filed. The important fact is that, my lord, there was no land acquisition process. The lands were acquired on temporary basis by the railways. And in respect of few landowners, already lease charges were paid. Their lands were returned to them also. These all are admitted facts, my lord. I think my learned friend will also not dispute. But subsequently, another set of landowners, my lord, they approached the court.
You see, it still would not be a ground for review.
My lord.
It would be at best a ground for appeal, but may not be a ground for review. Review is only limited to three consequences.
My lord.
There are three postulates of review.
My lord.
First postulate is that
So there has to be error apparent on the
error
face of
apparent on the face of record.
Yes.
So if it is a wrong decision of the court, it can't be an error apparent.
My lord.
Second is that any material which after due diligence would not be.
My lord.
Your case does not also fall within that.
I'll try to.
If you say that it is an admitted case, that means we'll have to presuppose that these pleadings were there on record.
No, admitted so far as what facts I have said. I will come to the main point. I was just narrating the facts, my lord. My lord, in that background, the writ petition was filed, my lord. The another 153 set of landowners, my lord, they approached the honorable court, my lord. Now may I take, my lord, to the order, my lord, passed by the learned single judge, my lord, in the review petition. Review petition. On page 21.
You come to page, come to paragraph 9 and 10 of your affidavit in position filed in the writ petition.
Our affidavit, yes, ma'am.
Yes, para 8 and 9. So that is your case. So if this court has wrongly appreciated that,
No, no.
It would be a case of appeal. It can't be a case of
No, Lord,
review.
when we filed the writ appeal, my lord, the learned division bench was of the opinion that since there was a consent given by, my lord, some railway officer in the court, my lord, and so it's a consent order. So therefore, my lord, the court directed us to prefer a review.
What is the consent?
My lord, the
Sure, sir.
consent was in fact, my lord, contrary to our stand taken in the affidavit in opposition, my lord. In the affidavit in opposition, we have categorically stated that.
Have you departmentally proceeded against that person?
My lord, because that is the reason, my lord, why now in the
But
review
that's okay.
petition. My lord,
One officer has given an incorrect order, sorry, representation before the court. Have you proceeded against him departmentally?
that I have to take instruction at the moment, not having the
Get that
information.
instructions. Otherwise, we can't say that he has, you see, how can we presume that the man stood up before the court and made a statement contrary to records? He had appeared in person.
If I may, read the learned single judge, it's 3 pages order only, my lord. If I may read the order, my lord.
Yes, go ahead.
My lord. Page,
Because you see, you take a call.
my lord.
Because subsequently we will not be permitting you to get instructions, because if we hear it, we dispose it off. If we hear the matter, we bring it to a quietus. We would not adjourn it. After hearing, we are not adjourning it. You take a decision. If you want to proceed, you proceed.
My lord, the nature of the consent, that's what I was just trying to read the order, my lord. In what,
No, when you say we accept it,
my lord.
once you say that, we accept it. We are not disputing the statement made by officer of the court.
No,
But the question is, if you want to proceed with the hearing, please do. But then we are not adjourning it.
my lord,
Then we dispose of on merit. Please
No.
proceed.
my lord. My lord, page 21, my lord, it
Of
is,
the review petition,
my lord, it is the judgment, my lord, on the top of it. The judgment is annexed immediately after the synopsis, my lord. And the certified copy, page number, my lord, on the top, it is
yes.
1 of 24, my lord. My lord will take page 21, where the main judgment starts from, my lord.
Yes.
My lord. Heard Mr. K.K. Montal, learned senior counsel for the petitioners, and Mr. C. Borough, learned counsel for the respondents in the NF Railway. Also heard Ms. M. Burman, General Junior Advocate, and for the Deputy Commissioner and other district administration officials of the Dhemaji district. Without going into the details, it would be sufficient to take note that the claims of the petitioner is that the land was under their occupation was taken over by the railway authorities for the purpose of construction of certain service roads for the railway line, but no compensation in lieu thereof has been paid to the petitioners. After a detailed deliberation, Mr. Kinkar Das, Executive Engineer Construction, Pasighat, NF Railway, upon verification of the records, makes a statement before the court that the land of the petitioner was utilized by the railway authorities for the purpose of service road, but no compensation thereof have been paid. Accordingly, Mr. Kinkar Das makes a statement that the railway authorities will give appropriate consideration to the matter and ensure that whatever compensation the petitioners are entitled under the law to be paid in lieu of the land that has been taken would be paid. A stand is taken by the railway authorities that the land of the petitioners is a government land. In this respect, we take note of a communication dated 26/2/2016 from the Deputy Commissioner Dhemaji to the Deputy Chief Engineer Bogibri Bridge Project, Silapathar Dhemaji, providing that certain land has been used for construction of service road from Kulazan to Karinghat Bogibil project, but in respect thereof, compensation has been paid to 53 affected landowners, but another 148 landowners had been excluded from the benefit of payment of such compensation.
Accordingly, the Deputy Commissioner estimated an amount of rupees 9,93,620 for annual patta lines that have been utilized by the railway authorities, and another amount of rupees 2,36,79,300 in respect of another 219 bighas, 4 kathas, 16 lichas, which apparently appears to be government land under occupation of the respective landowners. Accordingly, a request was made that the amount aforesaid be released at the earliest. The railway authorities, in response thereof, by the communication dated 29/2/2016 from Yashpal Singh, Deputy Chief Engineer, NF Railway Silapathar, had informed the Deputy Commissioner that the land was taken on temporary lease for the service road from Kulazan to Bogibil, but in respect of such temporary leasing, the railway authorities can give compensation either to the individual patta holders or to the government for government land. If it is the stand of the railway authorities that in respect of the government land under occupation of the respective landowners, the railway authorities will pay compensation only to the government and not to the landowners, be it so, but let the appropriate compensation be deposited to the government, that is through the Deputy Commissioner Dhemazi. We take note of that calculation. We take note that the calculation of the Deputy Commissioner of the aforesaid amount was made on 26/2/2016. And in the meantime, more than 6 years has passed by, meaning thereby if the amount had not been deposited and incidentally paid, it will carry interest as because it was deprivation of compensation to the landowners. If the interest is not paid, it would amount to allowing the respondent NF Railway authorities to take benefit of delaying such payment of compensation without appropriately compensating for certain amount. Accordingly, as agreed upon by the concerned official of the NF Railway before the court, the Deputy Chief Engineer Bogibil project to do the needful to pay the amount required by the Deputy Commissioner in the communication dated 26/2/2016. And in doing so, the Deputy Commissioner shall make a further communication to the Deputy Chief Engineer Bogibil project as regards the escalation of compensation by including the relevant interest for the purpose, and the said amount be also accordingly paid. Further, if the Deputy Commissioner.
Can we
on-
review it?
My lord.
These observations, can we review it? Can we substitute this judgment?
My lord, so far
with,
as the.
Another view.
My lord, so far as the portion, the statement given by the official that for the government land, the compensation has to be paid to the government, my lord. That statement, my lord, was contrary to the stand in the affidavit, because we have categorically stated, my lord, page 155, paragraph 15, that.
He consulted the papers. The court writes in the first line. He consulted the records and then told. If you consulted the records and then said, and you're not drawing up any disciplinary proceedings against him, how can you presume that he has done something which is incorrect from the records? Those records are now not before us. So we don't know which records he saw. What is the contents of the record? What did he place before the court? We don't know that.
Not a question of law would arise, my lord, whether for a government land compensation can be paid, my lord. Because apparently, my lord, a government land, the authority vests in the state government, my lord. I have
No,
judged,
we know that we are not infallible.
my lord.
It's a well settled legal proposition. So if you have failed, appeal is the correct remedy available. How can we review it and substitute it by now saying that the land, you see, we'll have to say 4 things. Number 1, we have to say that there is no acquisition proceedings drawn up. Therefore, question of land compensation will not arise. Number 2, we'll have to say that the proceedings for acquisition and requisition of land under 64 Act or rules has not been followed. Number 3, we'll have to say that the officer who came, he consulted the records and said, which is contrary to the finding. But where is the record to justify that what he said was wrong? And 4th, that the order of compensation to be deposited in view of the statement made is incorrect. So four things, how can we substitute the judgments at the time of, and there's no error apparent on the face of the account.
Well, on the point of, my lord, adjudication, well, so
Shows
far
any
as.
authority, shows any authority where it says that
My lord,
incorrect, incorrect perusal of records.
no, paragraph 88, 89, and 90. Or- My lord, 2005, no, I'm relying on
Just
the-
a moment.
my lord.
Paragraph,
Now, paragraph 88, 89, and 90. My lord. Two thousand five, 4 SCC, 741.
please read which part is
Paragraph,
favorable to
my
you.
lord, paragraph 88, may I read, my lord?
Yes,
So section 114 CPC empowers a court to review its order if the conditions precedent laid down therein are satisfied. The substantive provisions of law does not prescribe any limitation on the power of the court except those which are expressly provided in section 114 CPC, in terms whereof it is empowered to make such order as it thinks fit. Order 47 Rule 1 CPC provides for filing an application for review. Such an application for review would be maintainable not only upon discovery of a new and important piece of evidence or when there exists an error apparent on the face of the record, but also if the same is necessitated on account of some mistake or for any other sufficient reason. What would constitute sufficient reason would depend on the facts and circumstances of the case. The word sufficient reason in order 47 Rule 1 CPC are wide enough to include a misconception of fact or law by a court or even an advocate. An application for review may be necessitated by invoking the doctrine actus curiae neminem gravabit. Thus, a mistake on the part of the court, which would be a mistake in the nature of undertaking, may also call for a review of
so it
the
is either by a court or by an advocate. So we'll have to substitute the Supreme Court judgment by saying the misconception of law by a representative of a party.
My lord, but my lord, since the public money would be involved, my lord, we have no problem in paying the amount to the patta landowners, my
No,
lord.
we don't know. If you have no problem, pay it. Why
But,
this
my
review?
lord,
Why this contempt? Why you're not complying with the order then?
Because, my lord, the direction, the authorities have assessed the compensation for the government land also, which apparently, my lord, I have the judgment of the Supreme
We
Court,
challenge that.
my lord.
that means you can't have a collateral challenge here. In their writ petition, you can't have a collateral challenge. If we had a concept of counterclaim in a writ petition, I would have been happier.
Not we had earlier filed the writ appeal, my lord, but the court, the honorable division
No,
bench.
you see, they don't say anything to the court because the court has not said that we directed them to file a review. The court said that your prayer, you are withdrawing it.
My lord.
So we go by that order. Those are sacrosanct. We can't change the
Yeah.
purport of the order by saying that the court compelled you to withdraw it. Even
Yeah.
today, I have compelled you. Either you argue or you take an adjournment. We compel you to argue.
My lord.
So we do that exercise at times. But the record says that you have voluntarily argued. So it rests at that. You can show us this anything. You see, when you are reading paragraph 90,
My lord.
it's only court, mistake of a court. First line is mistake of the court. So assuming that you make a statement which I wrongly record it, it's a mistake of the court.
My lord.
And then it says that you see there can be another example. I have passed a order in one of the cases. I've gone to the extent of saying that the incorrect interpretation of a Supreme Court judgment, being the law under 142, will also give rise to a review. I've gone one extent further. Because if there's a judgment of the court which I misread or not followed, in one of the cases I've accepted to be the mistake of the court. Because if I have committed a mistake, it won't harm by admitting it that I made a mistake. But that was the situation covered by section 19. Because I have to follow the law. If I don't follow the law, then understood. But if somebody comes and makes a statement that I'm ready to pay, how it can be a matter of review?
Only on that part, my lord, the government line, my lord, because, my lord, at the direction given by the legislature in paragraph 5, my lord, would actually also, my lord, because in subsequent paragraph, my lord, there is a direct paragraph 5, my lord, the observation is that, my lord, if it is the stand of the railway authorities that in respect of the government land under occupation of the respective landowners, the railway authorities will pay compensation only to the government and not to the landowners. Be it so, but let the appropriate compensation be deposited to the government through the deputy commissioner. And my lord, thereafter in paragraph 7, there is a direction to pay it to the landowners. And my lord, the affidavits filed by the deputy commissioner, that also, my lord, clearly states that they were encroachers. My lord, the affidavit filed by the deputy commissioner, the revenue authority. There, my lord, there is a categorical statement that the petitioners, they are encroachers on the government land and they are not entitled to compensation. Now, my lord, the same authority is assessing compensation. My lord, we'll peruse the affidavit by the deputy commissioner at page 116.
So if I'm inclined to close this matter, we'll make observations on the submissions made. And we'll merely say that the order would not be implemented in that contempt. We adjourn that matter for 1 month. Within that time, you can do whatever you want, you can do it. Now, we postpone that enforcement of the order for 1 month.
Lord, will give us liberty to file appeal in that case. My lord.
That is your right.
My lord.
Why we are not entertaining the review, will say that only.
No.
Liberty is for you to exercise. Yeah.
Well, even otherwise also, what my friend is saying, that for government land compensation is not required. Well, even if a patta land is acquired by the government, under section 10 of Assam land acquisition order, it becomes government land, my lord. Ownership based.
No, there you will fail. If you enter into the merit, you have a bad case. Because you see, a compensation, land acquisition compensation cannot be made without a declaration and what you call orders under section 4 or 6, without compliance of that. And the second is that
Even in that case also, it is the state government. Railway is nothing. Their stand is that, my lord.
no, if you permit, if you give concession, then we go into the merit.
No. No.
Because we are prepared to take it. You have a bad case as far as facts are concerned. Number one, the land was not acquired. Without land acquisition, there cannot be a direction to make payment for land acquisition. Number two, if the land is not requisitioned under the 64 Act, Land Acquisition and Requisition Act, then section 3(4) will not apply, and therefore the land user compensation or right of way compensation can also not be granted.
No, that's true, my lord. But my lord, their stand is that.
No, then we don't enter it. Either I enter into the merit or I don't enter. It can't be midway. And you see, there's one more thing which Mr. Gupta has not argued. This person who came and gave a statement before this court was not a party. Executive engineer was not a party in the writ petition. He could not have been heard by the court to record his undertaking.
No, he was there only representing the railway, my lord.
He could not have. Unless he shows the authority to represent, and that's not being recorded. He's not a party. Therefore, even otherwise on merit, I may exercise the power of review only on that ground alone. I give you the choice. We enter into the merit or not.
No, review is, my lord, that your
Also, because I'm also relying on the judgment, my lord, to support the. Paragraph 20 and 21. Misconception of fact or law, my lord, that is also a ground for review, my lord.
No, tell us whether the court has committed that.
Yes, my lord, because there is a direction to pay compensation for the government land, my lord, which admittedly, my lord, cannot be paid. And there is a Supreme Court judgment which I am relying on, paragraph 20. It says that, my lord, government land, my lord, it vests in the government and there is no question of acquisition of such land. When there can be no acquisition, my lord, there is no question of paying any compensation. So far as the patta holders are concerned, my lord, we have already paid. My lord, in state of Orissa versus Vrindavan Sharma, my lord, reported in 1995, supply 3 SCC 249. This court has held that the land acquisition does not contemplate or provide for acquisition of any interest belonging to the government in the land on acquisition. This was reiterated in a subsequent decision of this court in Meher Rusi Dalal versus Union of India. In paragraph 15 and 16 of the said judgment, this court has held that the High Court clearly erred in setting aside the order of the Special Land Acquisition Officer, declining a reference, since it is a settled law that in land acquisition proceeding, the government cannot and does not acquire its own interest.
Again, you'll have to show us. You see, the railway, if it is acquiring, it is the one of the organization of the Union of India.
My lord.
The land which is being used is a government land of the state of Assam. Now, is there any understanding between you? Because you see, you can't substitute union government with the state government.
My lord.
So now, is there any agreement that the state government will give you the land free of
No,
cost for the railways?
My lord, in the affidavit filed by Deputy Commissioner, my lord, the government, there is a statement by the Deputy Commissioner that the government will pay the lease. The railway will pay lease charges to the government, but not to the owners, my lord. The
Where is that?
person who are in possession of the government land, my lord, they cannot be paid compensation. Now, this is what I am trying to submit, my lord. There is a statement, my lord, by the Deputy Commissioner that the landowners are
Sure, that-
encroachers.
Shows that.
My lord, page 116, my lord, we'll take the writ petition, my lord, the file, writ petition file. Page 116, my lord. Paragraph.
Paragraph 4, last two lines.
Yes. Yes, my lord. Paragraph 4 and 5, my lord.
No, what is this 53 families were compensated? What
They
is
were, my
that?
lord, initially, my lord, they were compensated. Lease charges were paid, my lord. In the contempt petition, my lord, I have annexed the documents, my lord. My lord,
They, my lord,
there is a deed of agreement, my lord.
They entered into personal agreement with the some landowner. Those are agreements are there, my lord, in the item.
Those are 53.
53 number.
My lord, how
That
they
is for
can, my
lease
lord,
charges, my lord.
personally, my lord, the lease agreement with the private.
Because the land were acquired on temporary
No, whatever
basis.
they do, they can do it. Because in this case, in a similar matter,
My lord.
this bench has dealt with an issue where land acquisition compensation was settled by the government even after the what do you call, after the
Expiry of the notification period.
no, after the compensation was ordered under section 18 by the district judge. Even after that, the government entered into an agreement, and that agreement is valid otherwise, because a decree can be assigned, and the decree by agreement between the parties under section 25 of the Contract Act can enter into.
No, that's my lord with the state government, my lord. Because my lord, railway
No,
or
what
the
is
union
that?
government, my lord, that by themselves, my lord, they cannot, without involving the state of Assam, my lord, how they can, my lord, and my lord, so far, my friend is
No,
saying
how
that
they
the.
can that, it's not under challenge, so we may not answer that. We'll have to answer what has come out. But if they have done it, in the interest of the project, if they have done it, because they may have hundreds of reasons
Yes,
to do so.
yes, that's true. And my lord, secondly, my lord, the land, my lord, they say that they have taken for temporarily, my lord. The land was taken on even on lease with the private in the 2004, my lord. Now in their 2013, my lord, they have again issued letters to those lessors, my lord, for renewal of the lease. So my lord, it is more than, my lord, 10, 15 years now, my lord, 2024. More than 20 years, my lord, how it can be a temporarily, my lord, lease, my lord. It has acquired the nature of permanent acquisition, my lord.
You don't know.
Those
can't answer that.
letters for renewal also on the, my lord, in
You can't
the.
answer that, but if they have done it, somebody will have to challenge it.
And the stand of government is also very clear, my lord, page 100 of this review petition, my lord. It is the letter from the Deputy Commissioner Demaji to, my lord, the Principal Secretary Government of Assam Revenue Department. There, my lord, in
So
that
just
letter
a
also.
moment. Just a moment.
Media to approve.
You have paid land acquisition compensation for how much quantity of land?
My lord, we have paid in respect of 53% initially.
No, no. 53 is okay,
My lord,
but what is the quantity of land?
my lord, that my lord, it will be 63 bighas, my lord. 12 lisas. My lord, page 55 of the contempt petition, my lord.
You have the writ petition set with you?
Yes, my lord, it is annexed in the,
Yes. Now come to paragraph 8 of the writ petition.
yes,
Yes. In paragraph 8, fourth line, you read first 5-6 lines.
my lord. That the petitioner begs to state that a deputy commissioner Remaji in the meantime again issued a letter dated 26/2/2016, and they informed that the respondent number 3 that the land measuring 7 bighas 0 lisas annual patta land and 219 bighas 4 katta 6 inches government land, which the petitioners were holding. A list of them already submitted have been used for construction of service road from Ulazan to Karangahat, Bogibeel Beach since 2004.
Correct. Now, this para 8. In your reply,
I have to confirm this wrong contemporary. Our affidavit. Yes, ma'am. There we have stated that the lease amount has already been released as per the lease agreement.
now, having read that, you come to the government affidavit at paragraph 10.
But I don't have the copy of the government affidavit was sent there.
You take this. Page 117, running
Yes.
page.
Yes.
So, need to paste this. Reply to paragraph 8.
No. That we have said that we have paid lease to the landowners as per the lease agreement.
No, no, no. The government affidavit. I opened it up for you.
Well, this is our reply, my lord. This is a reply by the railways, my lord.
Find the government affidavit. Paragraph 10. It's not there.
Two and three. no? Petitioner.
Affidavit by Hemanta Kumar Datta.
Yes. Paragraph. Yes.
Paragraph 10.
10.
They said
That
that
would-
you are utilizing the government land, give us compensation, then we'll decide what to do with that money. See, that is the
Yes.
stand. The government is the order of this court is absolutely correct. You pay that amount, and if required, then they will pay it to them. This is the stand of the government.
my lord. But there is a direction to pay to the landowners, my lord. Subsequently in the
No,
judgment.
that's okay. That is
That
between the
may be
government and
carried-
all. The government admits that they will take the money and then do it whatever they want with that money. That means the government has intention to pay to the land, to the encroachers. It's very clear.
Yeah.
Railway was requested for taking land on lease from the government as government land, and subsequently government will decide what to do with the lease amount to the encroachers or not. So therefore, you'll have to pay compensation. There is no agreement that you will get the land free.
But there has to be, my lord, clarity, my lord, whether the money would go to the government only, my lord,
No,
because,
You see, for that you don't have to worry.
my lord.
For that you don't have to worry. If you ask for modification of the order, that we pay to the government, not to the landowners. So far that is agreeable.
No,
But
that
you
is
can't
also,
dictate
my lord,
that-
payment has to be deposited.
That part, my lord,
Now,
we are
whether,
agreeable. That is what the clarification we want, my lord, because there is a direction, my lord, there was a subsequent paragraph, my lord, there was a direction to pay it to the landowners. That was creating a confusion, my lord, because my lord, we'll see the last page of the order.
You see,
The-
therefore you see everything falls in place. The executive engineer who comes, who looks at the record and says that we have no difficulty in paying. Then the government affidavit says you give us the money, then we'll decide what to do with that money. And the judgment of this court saying that for first part is that you
But-
deposit
yes,
money and then we'll do whatever it is. The second part, it says that we'll pay to them.
Yes.
So if you don't want to pay to them, you pay to the government. They will decide what to
That
do.
has to be clarified, my lord, because the DC has asking the railway to pay to the landowners, my lord, will page 207. 207 of the review petition, my lord, subsequent to the single bench judge's order, my lord, page 207, my lord. It was November 2023. My lord, okay, my lord. My lord, first paragraph, my lord. What the deputy commissioner, what the first paragraph is saying, not that we pay for the government land also. To the landowners, and we are asking for the ownership document, my lord, to comply with the order. Which the deputy commissioner is repeatedly not providing, my lord, because in the contempt petition, my lord, we have a series of communication requesting the Deputy Commissioner to provide ownership documents in respect of those 153 so that we can pay them. Which admittedly, the Deputy Commissioner is now saying they don't have ownership documents. And also, my lord, one.
Correct. If they are encroachers in the government land, they will not have documents.
My lord,
Land in the city, because government is saying is government land,
yes,
so encroachers will not have documents.
yes.
And then you see, those things doesn't take us anywhere, it's just spending the time of the court. You see, come to this paragraph 1. If you have read it, you will find it that the verification was made in the presence of railway officers.
Yes, joint verification.
Then,
My lord, if the railway, my lord, is directed to pay it to the government, my lord, let that part be clarified. It should not go to the land owners as they are encroaches. That is what our submission is. It will not go to
no,
them.
it's okay. He wants to pay to the government, let him pay to the government.
And government will take it in accordance with law.
My lord, the encroaches are
No.
what, how he can say, my lord.
There is a
No,
affidavit, my lord,
You
by
see,
the Deputy
everything,
Commissioner.
I told you,
My lord.
insofar as the respondent petitioners are concerned, I have full conviction that they have no case.
No, that may be, my lord.
Correct. So therefore, you see, those questions are pertinent questions which somebody is raising.
Let the government decide.
The encroachers, under which provision of law an encroacher will be getting compensation?
Yes.
And if you are directing that, it gives a premium to the encroachers.
No, my lord, the deputy commissioner submitted the report that these persons have been occupying the land, my lord, since 1971.
Maybe since 1947.
And they have been cultivating this land.
That's okay. But when government land you are cultivating, what at best can you get?
Now, my lord, many of the other persons, all they've been.
No,
given
but they
patta.
have a separate agreement.
Yes.
If as an encroacher, I'm getting some money and leaving it. They're
Let,
paying me money.
let them deposit before the government. That can.
Paid before the government then. Because per se, the order would not be sustainable in appeal. The reason being there's no rank acquisition itself, even under requisition proceedings, that proceedings must be drawn up.
There is no requisition proceeding also. There is no requisition process
So
also.
the,
Before the land
direction to pay land acquisition compensation itself is per se
But
we will not call for conference of this bench at least. Although we have to respect the order of the coordinate bench, but I can't concur. That's why. But Mr. H. Gupta done it. Easy appearing for the respondent, review petitioners. And Mr. J.C. Gaur Leonard, counsel for the respondents,
my lord.
for all the respondents. No, not for all the respondents.
1 to 150.
1 to 151.
Yes,
1 to 151.
150.
And you are appearing, Ms. Bhagwan?
I'm in the conference session.
Oh, acha. Ms. Burman, you are there?
Your name is there.
And Ms. M. Burman, then government advocate, appearing for responding numbers 152 and 153.
Yes.
The review petitioners are the Union of India and the Deputy Chief Engineer within bracket construction Bogaville Bridge Project, NF Railway. Next paragraph. This review petition is directed against the order dated 9/9/2022 passed by this court in WPC 6884 of 2017. Next para. At the outset, the learned CGC has submitted that the petitioners had initially filed an appeal, a intra-court appeal against the impugn order under review, which was registered and numbered as WA 417 of 2023. However, comma, with liberty to file this review, comma, the writ appeal was withdrawn by the order dated 12/1/2024. And accordingly, the present review petition was filed. Next paragraph. Amongst others, comma, the review is presented on the ground that the consent given by the executive engineer by Mr. Kinkar Das, we will give his name, Mr. Kinkar, Kinkar Das, executive engineer within bracket construction, comma, Pasighat, comma, NF Railway, which is quoted in the impugn order dated 9/9/2022, is contrary to the stand taken by the petitioners in para 10 of the affidavit in opposition. As it was the pleaded case of the petitioners in their affidavit in opposition that the land was taken on temporary lease for the purpose of service road from Kulajan, Kulajan, to Bogie Bill, Bogibel, and that the compensation for temporary release of the government land cannot be given to the individual occupant of the enclosure of the land. Full stop. It is submitted by the next para. It is submitted by the learned counsel for the review petitioners that the land for which the private respondents are claiming compensation relates to government land measuring two one nine bigha, 4 katha, 16 lecha. Where the private respondent numbers 1 to 151 were occupying. Full stop. In your statement made in paragraph 8 of the writ petition, comma, on a query by the court, the learned CGC has submitted that insofar as 53 numbers of land affected owners were concerned, comma, there was a private agreement with them for paying compensation. And therefore, it appears that in respect of land of 219 bigha, 4 katha, 16 lecha, comma, apart from the government of Assam, comma, the interests of 151 private respondents are also involved. Next paragraph, the learned CGC further submits that as the concerned land is a government land, comma, no land acquisition proceedings under the erstwhile Land Acquisition Act, comma, 1894, or any acquisition and requisition proceedings under the Assam Land within bracket acquisition and requisition bracket Act, 1964 was initiated. Stop. By referring to the decision of the Supreme Court of India in the case of Assam Industrial Development Corporation Limited versus Gilapukri, GILLAPUKRI, Tea Company Limited and others, comma, within bracket 2021, bracket was 3 SCC 338. Comma, it is submitted that it is well settled legal proposition that if a land already stands acquired, already stands vested in the government, comma, there is no question of acquisition of such land. Hence, comma, it is submitted that without any acquisition or requisition proceedings, comma, the review petitioners cannot deposit acquisition compensation in the name of the private respondent numbers 1 to 151. Full stop. Next, in view of the stand taken in paragraph 10 of the affidavit in opposition filed by the respondent number 4 versus filed by the Deputy Commissioner Nemaji in WPC 6884 of 2017, wherein it is stated that the Railway Department was requested for taking government land on lease by office letter number capital DLA full stop 41/2014/172 dated 26/2/2016 from the government, as it is a government land, and subsequently government may decide whether to pay the lease amount to the encroachers or not. The learned CGC upon instructions submit that if payment is required by the government for lease of the government land, the railways would be making disbursements to the government through the Deputy Commissioner Dhamaji, but in no event the railways are empowered to pay lease amount to the encroachers of the government land. Full stop. In this regard, it is further submitted that the Deputy Commissioner Dhamaji has also admitted in paragraph 13 of the affidavit in opposition that as per the document submitted by the circle officer, CC Borgaon, SISSIBORGAON, Revenue Circle, all the names of encroachers are recorded in the Chita copies. Full stop. Now the government incorrect document is placed in your affidavit filed in the writ petition. The document is incomplete. It's not available with you. Look at this. We have sent you that second file. Take it from the postmaster. In the affidavit in opposition, the list you have given is incomplete. That second file. Second file. You got the document, affidavit you have got
Yes, ma'am.
in your affidavit, annexure 5. You got annexure 5? Hmm? Page 1 has serial number 1 to 9. You got it?
Statement of exception.
Statement showing names. Correct. First column is 1 to 9. Second column is 1 to 26. Third page is serial number 18. It can't be. That means pages are missing.
That is for I have remembered my lord, that there is a use bunch of papers.
No,
The
but
relevant
you see,
except-
when you withhold documents,
Yes,
now we were not finding 151 people.
yes.
Then,
Probably it is expected where motion was sent to us. or
no, but
maybe-
you should have said that the incomplete list. Your affidavit becomes a false affidavit.
That at that time record was there, but it was produced by the honorable court, my lord. It is confined to that extent, I have remembered, my lord, to the extent that
Because I have a very
petitioner's
bad
names are
habit
there.
of cost checking. I took up the calculator, I'm starting to calculate and it doesn't come to 151. So now we found out that it is wrong.
That might be the thing,
Ah.
relevant extent we have annexed and the record was produced before the court, my lord, at the time it's reading.
I have a bad habit. I like faces, but not the face value. Correct.
But it was brought to an extent. I
No,
have
whatever we,
remembered,
but
my
now when we are looking at it, if it is incomplete.
lord. Petitioner's names are there.
So accordingly, comma it is something that contrary to the records and the law relating to land acquisition or requisition, comma, the railway authorities are unable to concede for payment of land acquisition compensation to the enclosures and therefore the consent given by the officer was not a valid concession which calls for a review of the said order dated 9/9/2022. Next paragraph. Per contra, comma, the learned counsel for the private respondent numbers 1 to 151 has made his submission in support of the impugn order. And it is submitted that in view of the specific statement made by the officer of the railways, comma, such statement partakes the character of an admission, and therefore the railway authorities are bound by the bound to comply with the order imputed in this review petition. Full stop. It is also submitted that the railway authorities have entered into an agreement with 53 other landowners, and as the petitioners are similarly situated, comma, land acquisition compensation to them cannot be denied. Full stop. Next para, however, comma, on the specific query of the court, as to whether the respondent numbers 1 to 151 would have objection if the money is not paid to the respondents but deposited in the deposited before the Deputy Commissioner Dhemaji. The Joint Counsel for the private respondents submit that that you may agree to the same. However, the money earmarked for the 151 private respondents should be released to them by the government. And obligor the Deputy Commissioner Dhemaji. Next paragraph. It would first be required to examine as to whether the issue raised by the petitioners call for exercise of jurisdiction of the court to review the order dated 9/9/2022 passed in WPC 6884 of 2017. Next, in this regard, to demonstrate the power of the review being available to the court if incorrect undertaking is given by the executive engineer within bracket construction, Pasighat, NF Railway, the learned CGC has placed reliance on the case of Board of Control for Cricket in India and another versus Netaji Cricket Club and others, within bracket 2005, bracket was 4 SCC 741. Within bracket para 88 to
90,
90.
88 and 90.
So they said paragraphs are quoted below. Para 88 starts as we are, comma, furthermore, comma, of the opinion. It starts like that. Next paragraph. We take notice of the order dated 5/9/2022 passed in WPC 6884 of 2017. Stop. In this said order, this court had recorded that the annual patta land of the petitioners was taken over by the railway authorities. The construction of service road leading to Bogeyville Bridge, and also recorded the stand of the railways that the land is a government land for which they are refusing to pay compensation to the petitioners. Accordingly, this court took note of the provisions of right to fair compensation and transparency in land acquisition, rehabilitation and Resettlement Act, 2013, and held it to be beneficial legislation for the landholders. And therefore, this court had required the railways to substantiate from the law of acquisition as to under which provision of law such stands are acceptable. Full stop. Accordingly, the matter was fixed on 7/9/2022. And on 7/9/2022, the matter was adjourned to 8/9/2022. On 8/9/2022, the executive engineer within bracket construction, bracket close, of NA Railway was personally present. And he was directed to furnish the information to the court on 9/9/2022. Full stop. Accordingly, on 9/9/2022, comma, the executive engineer construction, within bracket construction, of Pasigat, comma, NF Railway, not only produced the records, but on verification of the records, a statement was made before the court. Full stop. Next paragraph, therefore, comma, the court is of the considered opinion that once the railways were directed to apprise this court of the factual aspects relating to law under which they had taken a stand, and the railway authorities having sent their executive engineer within bracket construction to address the court, comma, the said employee of the officer of the railways stand in the footing of the representative of the NF Railway, and the railways are bound by his statement, being the representative of the NF Railways. Full stop. Having taken such view, comma, the court is of the considered opinion that there was no mistake on part of the court in passing of the order dated 9/9/2022 in WBC 6884 of 2017. Full stop. Therefore, this is a case of incorrect purported incorrect stand taken by the officer of the railways. Full stop. If the review petitioners feel that they are aggrieved because of stand taken by their executive engineer within the construction is erroneous, comma, then the order dated 9/9/2022 can only be assailed in appeal, in intra-court appeal. Because the conditions precedent for invoking powers of review of there being an error apparent on the face of record is found to be absent. Next paragraph. Having said so, comma, we also take note of the submissions made by the learned CGC, stating that they may be granted liberty to deposit compensation to the Deputy Commissioner, Dhemaji, and the response by the learned counsel for the petitioner to the effect that he would concede to such prayer, subject to the Deputy Commissioner Dhemaji releasing the share of compensation to the individual respondent numbers 1 to 151. Full stop. Next paragraph. In view of, he said, stand taken, comma, the stand taken, comma, And having regard to the finding recorded herein before, the court is of the considered opinion that the order to this effect, the order in this regard would be more appropriate to be passed in the connected contempt petition. Full stop. Next, but accordingly, as the court does not find this to be a fit case for exercising power of review, this review petition stands closed. Now, in contempt petition, you're right. But Mr. J.C. Gaur, counsel for the petitioners. And Mr. You are appearing for? Mr. Hari Gupta, counsel appearing for respondent number.
Both the.
You just tell us this is a contempt.
You would be one in
One and
three, into three.
No, three, no, only one and two.
You're for?
I'm for
One,
four.
one and two.
You're for 1 and 2.
No,
You're for respondent numbers 1 and 2. Ms. Karen Badoli, then counsel for respondent number
Four.
4. You're for 3.
Number 6, your lordship. Respond number 6.
6.
Yes,
And
yes,
Mr. A. Das,
31st of March. He already declared 31st of March.
Mr. A. Das, then counsel for respondent number
6.
6. Next, madam. The learned counsel for respondent number 6 has submitted that the said respondent has superannuated on
31st of March, 124.
31/3/2024. So the counsel for the petition shall take note of this said statement. Next para. In context, in connection with the connected, not connected, in connection with review application number 12 of 2024, which was heard analogously, the learned counsel for respondent numbers 1 and 2 had submitted that as land acquisition proceedings were not initiated against the petitioner numbers against the petitioners, they are unable to pay the land acquisition compensation to the petitioners. However, in view of the stand taken in paragraph 10 of the affidavit in opposition filed by the Deputy Commissioner Dhemaji in connection with WPC 6884 of 2017, the release can deposit the compensation amount in the account of the Deputy Commissioner Dhemaji. To stop. On the said statement being made, the learned counsel for the petitioners has submitted that they would proceed with that request on the condition that the amounts are deposited before the Deputy Commissioner Dhemaji be released to the petitioners on account of their share of compensation. Next paragraph. In view of the stand taken in paragraph 10 of the affidavit in opposition filed by the Deputy Commissioner Dhemaji, the court is inclined to direct. The court is inclined to permit the respondent contenders to deposit compensation amount, consolidated compensation amount in the account of the Deputy Commissioner Dhemaji. Next, in the event such deposit is made, the Deputy Commissioner Dhemaji shall take note of the stand taken in affidavit in paragraph 10 of the affidavit in opposition, and And the pendency of this contempt petition shall not be a bar for the said authority to disburse compensation amount paid on due and payable to the petitioners. Next para. The in view of the order passed today, the enforcement of this order shall be past, the matter stands adjourned today, list after 4 weeks. So we have declined to do it. If you want to move again for the move again against the order, you are free to do so.
No.
So, एक minute. एक minute दिया. Okay.
No. No.
Mazul.
Yes.
Yes. Respondent number 6. Respondent number 6.
The petitioner should complete the new Yes. Yes. Apply. Correct. Yes, Your Honor. That's correct. Apply.
Apply.
May I please, Your Lordship. Your Lordship, as per the Lazima court's order, Your Lordship, dated 11/12/23, Your Lordship, service is complete, Your Lordship. So matter may be fixed for admission, Your Lordship.
বস্তু কম আন্দোলন করতে
Yes, Your Lordship. Yes, Your Lordship.
Lordship, for PNRD, I'm appearing. For Lordship.
P and 2.
U Sharma. Sir, Lordship, 1, 2, 5, 6, and 7.
A date may be fixed, Your Lordship. A date may be fixed, Your Lordship. Highly obliged. Highly obliged.
Obligement.
Time being item 25, supplementary list.
But shortly, I'll say, my lord. Since 2013, the petitioner was supplying buses. I'll try to help your lordship to. Short it. Well, yeah, since 2013, para 3 I have stated. Para 3. Like most of the time we remain in aircraft, we do not land. It happens. My lord. In cases, my lord, I find, my lord, we do cases and all, but we do not land. We land sometime, my lord, we don't.
No, that can be helped.
It can be helped. But problem is aircraft not landing is difficult for many persons.
No, nowadays you see it's very simplified. You have air-to-air refueling. So
No,
once
that is
refueling
there,
is
That is there, that's a dream for us, my lord.
so once you have air-to-air refueling,
Yes, that is there.
you can all be comfortable. Yes.
Para 3 I have stated, my lord. Your lordship will just note, my lord, since 2013, the petitioner was supplying buses to the institute. That is respondent number 3. Jorat Institute of Science and Technology. Now, others earlier we came to High Court and all. I'm not coming there. The lordship will kindly say an NIT was issued. Page 26. Notice inviting tender. It is dated 11/5/23.
We have any copy of registration certificate of your bus? No.
My bus is there. I could not apply. My case is that because of the terms and conditions, on the basis of the NIT, I was supplying since 2013. But they've given it to respondent number 5, my lord, who does not fulfill that qualification. They're not responsive bidder.
Okay.
And your lordship, these terms are vague. It is ambiguity is there, a lot of ambiguity is there. If there is ambiguity, my lord, and if there is vagueness in the terms and conditions, I cannot, my lord, I was not, my lord, given any place to even submit my tender. On that, my lord, I will place 2 decisions. One, your lordship will kindly see this terms and conditions of the tender is page 26 NIT, carrying again under Registration Act. Providing 2 buses on hire. Lordship got it, man.
Yes.
And next page is the terms and conditions. Here, my lord, the bidder vagueness is here, my lord. First, my lord, the bidder should be registered as travel agent, registered handling agent under Registration Act. My lord, I did not have Registration Act. I had GST and all, but so that has debarred
Service
me.
tax. Service tax.
Now, I have got GST registration. GST registration I've got, but this provision doesn't clarify that. It says, my lord, handling agent under Registration Act
No,
for
service,
providing,
service tax.
my lord, page 27.
Oh, acha. Okay. I was reading B.
No, A. As travel agent, registered handling agent under Registration Act for providing vehicles on hire for which the agent shall have to submit evidence of registration. So under this Registration Act, my lord, there is no provision for registration for the purpose of running, my lord, any tourist agent. Now, next is, my lord, your lordship will kindly. The vehicle offered shall be registered in the state of Assam only as commercial vehicle and in goods. That is all right, my lord, I cannot complain. Number F, my lord, your lordship will kindly see. F. The supplier must have at least one spared registered bus of similar capacity in his/her name. F. A, F, and G, my lord. The supplier must have at least one spared registered bus of similar capacity in his/her name or in favor of his/her name firm. Name against which he is submitting the bid of it. Now, they are saying, my lord, respondent number 5 has given affidavit of, of owner of other bus. So they are saying, therefore, he has met the criteria. Now, how many persons are responsive? I do not know. For that purpose, your lordship has called for the records. So here, my lord, what I understand is supplier must have at least one spare registered bus of similar capacity in her name, or in his favor, or in the name of his farm. So that means the vehicle should be in his name or in the name of his farm. It cannot be on the basis of an affidavit by somebody. I did not have that, so I could not even apply, although I was doing the business since 2003. Now, next, my lord, your lordship, G. The bidder or bidder's firm must have a qualifying experience of working in government department or any public sector undertaking firm. According to me, what we have filed in our affidavit reply, that the respondent number 5 doesn't have this qualification. So 3, my lord, A, F, and G.
This is for how many years, this tender?
3 years. Now, in their affidavit, what they say, my lord, very short campus, the whole petition is all about. In their affidavit, my lord, your lordship will kindly see page 56. He is the principal of the Jorat Institute of Science and Technology. What they say is this at paragraph 7.
56 or 59.
Huh?
59.
It starts from page 59.
Yes, paragraph 7.
Huh. Paragraph 7 starts from page 58. And the affidavit is at page 56 and paragraph 7 is at page 58. I just lordship got it.
Just a moment. Page?
Page, it starts from page 56.
Yes.
Paragraph 7, my lord. That while stoutly denying and disputing, may I read, my lord?
Yes.
Page 50, paragraph 7. I think it is at page 58. Maybe, my lord.
Yes, in my copy it is 59.
Paragraph 7.
Yes.
It is at page 59 in my copy.
Maybe, my lord. My is written 58, 59.
It's okay, I'll follow it.
Paragraph 7. The deponent begs to state that the respondent number 5 was accepted as a registered travel agent under Registration Act by scrutinizing committee on the basis of GST certificate. That should have been clarified in the NIT. NIT says under Registration Act issued by the government of India. So ambiguity is there, vagueness is there. Who registers him with a trade name Hero Tours and Travel with legal name as his own. Hence, his certificate was considered to accept his trade name as a travel agent. The registration trade license from local municipality block panchayat is a prerequisite to getting GST certificate in the name of travel agent. As such, the GST registration certificate itself was considered by the scrutinizing committee. This should have been stated in the thing. There cannot be vagueness. Level playing, my lord, field, if you want to bring, there must be clear terms that we are accepting GST. I have got the GST. I have produced in a reply. The GST I have been working since very long time. And I have bus, my bus is old. So I could not come. But as they are saying that I have taken affidavit from the owner of some other person, I could have also done. They are saying that only. Be it mentioned herein that nowhere in the scope of works and terms and conditions of the NIT, it is written that the bidder must have two buses on his own name. Here the term in favor of his or her firm is understood as to indicate that bus may not be in his name. How can one interpret in that manner? Or her name, but in favor of his her agency. The respondent number 5 applied as a travel agent only the very word travel agent is understood as someone operating bus, which may be, this is their internal understanding. Nothing is in the terms and conditions. No bus in the name of their firm also. The example considered was Renowned Network Services, which is a travel agency, but buses are not necessarily on the name of the owner of the agency, but this may be on the agreement between the agency and the owner of the buses. Here, hence, the power of attorney in favor of the respondent number 5 as a proprietor of his firm was accepted, which is the legal way of using bus from India and agency. This is not clear in the terms. Otherwise, I could have also hired a bus from that 5 years old. It should be 3 years old or not more than 5 years old. I could have also taken bus from anybody and put it in the terms. I also have got registration, but the vagueness of the terms and condition debars me from participating in the tender. Then, my lord, this is the contention, my lord, and the affidavit. In reply, my lord, I have shown, my lord, at page 69. Yeah, what to be getting? 68. On meeting respective conflict. No, not a Paragraph 6, your lordship, we have page 69. In my affidavit in reply. Paragraph 4 and paragraph 6. Page 68. I think it may be 69, paragraph 4. The deponent said that the respondent of I could not fulfill the terms and conditions of the notice inviting tender in as much as he does not have any registration under the Registration Act as per terms and conditions of the aforesaid NIT, and the respondent of I has annexed MSME's registration certificate, which is not a requirement under the NIT. Because the deponent said that the repetition is an individual and proprietor of Ma Constructions and Supply Agency with due GST registration by number so and so, and he also owns 3 numbers of buses in his name, and he has been running 1 bus on hire to the respondent number 3. Now, paragraph 6, my lord, that with regard to statement made in paragraph so and so, the deponent reiterates and reconfirms that the respondent number 5 did not have the qualification of experience of running buses in government department, public sector undertaking as per clause 1G. So this is my contention, my lord. I'll just place 2 judgments. 2007 8 SCC 1. Paragraph 38, 39, and 53. Yeah.
38, 39, and
38, 39, and 53, man.
what is the name of the parties?
What is called? Reliance. Yeah. Reliance Energy Limited versus Maharashtra State Road Development Corporation. And the details I am not going, my lord. Cracks. Ultimately, it was set aside because of the ambiguity in the terms and conditions.
Yes.
When tenders are invited, paragraph 38, my lord. When tenders are invited, the terms and conditions must indicate with legal certainty, norms and benchmark. This legal certainty is an important aspect of the rule of law. If there is vagueness or subjectivity in the said norms, it may result in unequal and discriminatory treatment. It may violate the doctrine of level playing field.
Paragraph 38.
38.
Oh, sorry, I was doing.
May I read it again?
No, it's okay. Yes,
That level playing field, my lord, that word nowadays very often, my lord.
yes,
So certainty has to be there in the terms and conditions of the tender. In Reliance so and so, the bench of this court has held that in matters of judicial review, the basic test is to see whether there is any infirmity in the decision-making process and not in the decision itself. This means that the decision maker must understand correctly the law that regulates his decisions making power, and he must give effect to it. Otherwise, it may result in illegality. The principle of judicial review cannot be denied even in contractual matters or matters in which the government exercises its contractual powers. But judicial review is intended to prevent arbitrariness, and it must be exercised in larger public interest. Expression of different views and opinions in exercise of contractual powers may be there. However, views and opinions in exercise of contractual powers may there. However, such difference of opinion must be based on specified norms. Those norms may be legal norms or accounting norms, as long as the norms are clear and properly understood by the decision maker and the bidders and other stakeholders. Uncertainty and thereby breach of the rule of law will not arise. So it has to be very, very unambiguous, unambiguous and very, very clear the terms and conditions. If there is vagueness is there, it is only understood by the authority and some bidders, then the whole thing, my lord, smacks of their bad intention, my lord. Then paragraph, my lord, 53, my lord, it was set aside. Because of the vagueness, it was set aside. Hmm. 53. 59. 53, man. Because of the ambiguity, my lord, it was set aside. In the result, we set aside the interim judgment of the High Court. We hold that the Reliance HDFC consortium was erroneously excluded from the second stage of bidding process. Accordingly, we allow this appeal with the no order is supposed. Here, my lord, three conditions I have shown. That one has to be registered under another is, my lord, 2024 2 GLT 344. Question may arise, my lord, that you have not participated. I cannot participate because you have kept the my lord terms and conditions such a condition.
this is citation
2024 2 GLT 34, man. 344.
2024
2 GLT. 2
2
GLT
GLT.
344, paragraph 12.
What is the name of the parties?
Robi Bolwa versus Northeast NF Rolling.
Yes.
May I hand over the books, man? It is marked there. What is it?
I think for other matters, we will not have time.
What is it? Paragraph 12, my lord. It is well settled that an administrative authority is equally bound by the norms, standards, and procedure laid down by it for others. It must be held to be judged to norms, standards, and procedure by which it professes its actions to be judged. And it must also observe
I've
those
seen that.
norms.
I've seen that.
12, 13 and 16 and 17. My lord, if the norms are, my lord, vague, my lord, it has to be interfered with.
12, 13.
And 16, 17. So therefore, my lord, as I submitted with your lordship, three conditions your lordship will kindly see from the record. How many have participated? How many responsive bidders are there? And second, my lord, how many has met, whether these three conditions at page 27, A, F and G are vague or not? Because of these vagueness, my lord, I could not participate. So if it is vague, my lord, the lordship will have to set aside the tender which has been provided to the respondent number 5. So this is my submission for lordship. Yes. From the records, your lordship will see, my lord, whether the respondent number 5 have a qualifying experience of working in government department or in rest are, my lord, matters of records. Here.
I have the records, my lord. Lordship.
Deeply.
Correspondent number 1 to 4, my lord. I have filed my affidavit in paragraph 7, my lord, page number 59, my lord. First of all, my lord, he has not participated in the NIT, so he has no right to challenge his NIT, my lord. In paragraph number 7, I have stated, may I read, my lord? In paragraph 7 of the writ petition, department begs to state that respondent number 5 was accepted as a registered travel agent under Registration Act by scrutinizing committee on the basis of GST certificate. I have the GST certificate, my lord. Issued by the government of India, which registered him with a trade name of Hero Tours and Travels with legal name as his own name. Hence, the certificate was considered to accept his trade name as a travel agent. As registration of the trade license from local municipality block panchayat is a prerequisite to the getting as a GST registration certificate in the name of travel agent. As such, the GST registration certificate itself was considered by the scrutinizing committee as a proof of registration of the respondent number 5 as a travel agent. Further, his firm Hero Tours and Travels is also registered with Central Excise Department. I have that, my lord, Central Board of Excise Custom, that certificate, my lord. Further, my lord, the clause 1F.
You are appealing for 3 and 4.
1, 2, 3, and 4. Affidavit
Okay,
filed on behalf
1,
of
2, 3,
4.
and 4.
Yes, ma'am.
Affidavit is filed by respondent number 4.
4, ma'am.
So that's to show you something. Motor vehicle side.
Yes. Owner means a person in whose name a motor vehicle stands registered and where such person is a minor, the guardian of the such minor and in relation to a motor vehicles which is subject of hire purchase agreement or an agreement of lease or an agreement of hypothecation, the person in possession of the vehicle under that agreement. That is in respect of agreement, but this should be made clear in the terms. Yes, yes, that is. So this is for the purpose of insurance and all. I can.
Yes.
Person but in respect of tender, things are different, man. It has to be different. This is Motor Vehicle Act says so. Motor Vehicle Act is a different purpose, not in the realm of contract. Contract is different, man. It is governed by own terms and conditions, specifically by the NIT. Motor Vehicle Act is different. Motor Vehicle Act has got own purpose. I can't have an agreement, my lord, vehicle on the basis of an agreement. I can have it, but many questions are there, my lord. Whether if accident occurs, who will be liable? I remember doing a case in AIDC, my lord, when by virtue of an agreement, the vehicle was given to my lord AIDC. They have taken it. Accident took place. And who is to pay? Ultimately, AIDC, that owner had to pay. In court matter. Maybe this section 30 was not strong. It was done like that.
He can hire from the others. A travel agent can hire travels from
Yes,
the others,
we
my
can,
lord.
they
He
can hire.
Yes.
There is no,
There is
I'm
nothing
saying
wrong, my
about the
lord.
vagueness of the terms and conditions. If
There is
the,
nothing
if the
vague,
clarity was there, I could have also
if you are
participated.
not
No
participating in the
problem.
tender process, sorry, my sorry.
There I have already shown. There I have already shown to 24 GLT, even a non-responsive bidder, if he is a non-tenderer can also participate, when a challenge. If a non-responsive bidder is selected.
Now I come to my clause 1F, my lord. Clause 1F stated the supplier must have at least one spare registered bus of similar capacity in his sending out till higher division.
Creditors from the books.
On Monday, next Monday.
My lord.
Order hearing. Yes.
My lord.